one was expired on yesterday.
Matter of which year? It's a matter of which year?
2023.
Sorry?
2023.
Yes. Yes.
Okay, with the consent of the other parties, I would like to mention item number 2627. I have also given a
Matter of which year?
2019, Your Lordship.
Rejected. Yes. Next.
May please, Lordship, I would like to mention item number 37, Lordship.
Matter of which year?
2023, Lordship.
Lordship, in item number 54, we may file subsidy petition.
We have allowed your reputation. This Nam to lefale di dibo.
Today's daily course list, motion item 1.
May I please, Your Lordship? The matter pertains to the correction of the date of birth of the petitioner in her service book. It was wrongly put her date of birth. In
Has
the
notice been issued?
No notice was issued.
We issue notice?
Yes, madam.
Mr. Bora?
Lordship.
Heard MSc Bujurwal and counsel for petition. Also heard Mr. S. Bora, and standing counsel for the respondents in the BTC.
4, 5, 6, 6,
Ms. U. Sharma for secondary. Is it secondary education?
Element.
You are for elementary? Are you there or you are not there? For elementary, no, then who is there?
P. Bora, on last occasion, P. Bora was.
None appears for the elementary education department. The notice 6 weeks. Extra copies 3 days. Steps on the elementary education register post 3 days.
It is also important, my lord.
Sorry.
The control of examination, board of control examination.
They have to
That's
be
number 8. This is the
implemented.
Yes,
main
I-
party, madam.
Oh, party, no. Steps register post.
No problem.
Item 2 and 3.
Mr. Bora, rest of the respondents register post. Yes, sir.
Last order, my lord.
Yes, what is your instruction? What happened to the last one? Is it completed? Are you going to complete
Earlier not completed.
or you
but,
have abandoned?
But not completed, my lord. But now director want to.
Mr. Counsel, we are getting this answer every day. We
Yes,
want to know whether you want to complete or you have abandoned.
No, now director want to proceed. Put the case along with together.
The Director of Education BTC to remain personally present before the court to explain as to whether the earlier selection process pursuant to the letter dated 8/2/2022 would be completed or it would be abandoned.
No, not completed, my lord.
Next item, list on so and so. See, for 3 days, we cannot wait for one simple instruction. Let him come, we'll ask him. Only one simple answer, Mr. Counsel. Whether you are going to complete, if yes, on by which time, or you have abandoned it.
It is abandoned, my lord. And now the director.
It is abandoned.
Yes, my lord.
Where have you written?
Yes, only.
Then why don't you speak it out properly?
Now director want to proceed. Put the case together, my lord.
What do you mean by that?
Yes, last.
So let him come. It's better to take his statement.
Item 4.
Yes, Mr. Gogoi, do you appear for BTC? Who appears? Ask Mr. Naik to come.
Item 4.
This is, my lord, which against the amalgamation order page 17, my lord. This was the amalgamation order.
Page 17.
17, my lord. This is amalgamation order, my lord, of the
School is
petitioner.
amalgamated. On what ground you are challenging, Mr.
My lord, my lord, in fact, my lord, that amalgamation was the DLC, page 22, my lord, has recommended for, my lord, cancellation of that, my lord, amalgamation.
Amalgamation is also, there is also DLC for amalgamation.
Probably, my lord, as per my lord of the DLC, district level committee. My lord, page 22 is the, my lord. On the basis of that recommendation, my lord, there are another communication also. There also they have stated everything has been submitted for, my lord, cancellation. And director is sitting over.
Sorry,
there.
we have not understood it. There is an order of amalgamation.
Amalgamation.
Then what happened?
Then protested, my lord, by the village people and the students. my lord.
Somebody protested.
Yes, my
And
lord.
after the
An
protest, what
application
happened?
was made after the my lord, that
After protest, what happened?
the DLC has district level committee said, my lord.
In
They-
an amalgamation case, what is the role of a DLC?
I don't know what
DLC is for compassionate
No,
appointment.
my lord, this is
DLC
for the-
is for the provincialization. But for amalgamation, how the DLC comes into
this
play?
this is my the district elementary education officer has forwarded it, my lord.
So now what is to be done?
Now, my lord, the
No. Why is the petitioner before the court
everything
now?
is, my lord, forwarded to the director. Since 2019, my lord, 20.
Director is not doing anything.
Director is
That is
not-
your grievance.
Yes.
By which document it was forwarded?
Your lordship will find page 22, my lord.
Page 22. Minutes of the DLC. Where is the DLC?
My lord, the
Hmm.
my notes I don't have, but they have
But there is
mentioned about
some
minor.
DLC.
Yes.
Okay.
in page 24, my lord, your lordship will find a clear picture. my lord. Page 24.
Heard Mr. J. Pang, Learned Counsel for a petitioner for Elementary Education Department. Mr. Ganesh Pegu for Elementary Education Department. And anybody else?
Elementary.
No. Anybody else? Any deputy commissioner or no?
No. Deputy
Not there.
commissioner.
Yeah. Considering the nature of the order proposed to be passed, notice not required to be issued to the respondent number 6 being the headmaster of Gogol Dubi Mazgaon Lower Primary School. But as the matter is being remanded back to the director, if the director is of the view, the headmaster may be given a hearing. By the communication dated 28/3/2018 of the Block Elementary Education Officer Lokhimpur, the headmaster of Samor, what is that?
Samol to be my
Samor Dubi Dia.
Dia.
A dangerous place. Mr. Pine, dangerous place.
Yes, Dia.
So therefore the school is amalgamated
Yes.
to relieve itself of the identity. Samor Dia LP school. By the commission, it was informed that the Samordia Bidia LP school had been amalgamated stroke merged with the Borkelia, again Bidia LP school, Gogol Dupi.
And Kagol to be
Okay. The local public had protested against the amalgamation stroke merger. And as because of the protest, the matter was referred to a district level committee, and the district level committee in its meeting dated 5/11/2018 had taken certain decision. The said decision of the district level committee had been forwarded by the district elementary education officer Lokhimpur to the director of elementary education Assam by the communication dated 4/2/2020 available at page 22 annexure E1 to the writ petition. The grievance of the petitioner is that the director had not given a final consideration to the said communication of the district elementary education officer. Considering the limited grievance raised, we disposed of the writ petition directing the director of elementary education Assam to give a consideration to the communication dated 4/2/2020 and pass a reason order thereon. We are clarifying that we are not observing anything on merit as regards the amalgamation or the protest by the public or on the minutes of the DLC dated 5/11/2018, and we merely require the director to consider the merit on its own, consider the matter on its own merit and pass a reason order thereof. The reason order be passed by the director within a period of 1 month from the date of receipt of the certified copy of the order.
Item 5.
Mr. Gogoi, we'll take up this matter after some time.
No.
We'll hear
Yes.
what kind of order is to be passed. I think it's almost what I expressed, much order about nothing. We find there is nothing in this matter.
If at all they want to inquire into it, my lord, they will have to do as per the rule, my lord.
Give a notice, you go cooperate with.
It is required.
And secondly, after going to the register, we do not find any necessity of any inquiry also. It appears to be a genuine mistake by the dealing assistant.
Regarding the facts mentioned in that particular letter, if they want to, my lord, have it inquired, it will have to be for the block elementary education
It's up to
officer,
them.
that they can do
And
internally.
regarding the correction by the NUPA, we wait for some time till the outcome of the other process. Heard Mr. A.R. Bhuya, learned counsel for the petitioner, also heard Mr. P. Saikia, learned counsel for the. For whom do you appeal, Mr. Saikia? For the. No, Mr. B. Kosik for the authorities in the elementary education department, Mr. P. Saikia for the. Whom do you represent? Deputy Commissioner Borpeta?
District level scrutiny committee.
Deputy Commissioner, it's good enough. He is doing it.
5 and 6 I am appearing.
And Mr. B. Gogoi for the authorities under the SSA. During the pendency of the writ petition, the writ petitioner filed an additional affidavit dated 22/9/2023, wherein certain serious allegations were raised that on the instruction of the additional Deputy Commissioner Borpeta, one official from the where is he working? What MIS something?
MIS in the office of the block mission coordinator.
An official in the office of the MIS block mission coordinator Borpeta had threatened the writ petitioner over telephone regarding the requirement of certain documents. Full stop. Considering the seriousness of the allegation of a government official threatening litigant before the court, we required the personal presence of the Deputy Commissioner, who all were present the other day.
Additional Deputy Commissioner.
The additional Deputy Commissioner, the order to court good. The circle officer also, I think. No?
Yes.
Circle officer, the Gambura, as well as the official concerned, namely, what is his name? Wahidul Hassan. The additional Deputy Commissioner, upon personally appearing before the court, stated that in the writ petition, the petitioner is relying upon a communication dated 21/9/2021 from the additional Deputy Commissioner, EDN cum District Mission Coordinator SSA Borpeta, made to the Mission Director SSA regarding certain correction in the information contained in the dice code regarding the writ petitioner. But it was noticed that in the issue register maintained in the office of the additional Deputy Commissioner at serial number, what was it? 355. At serial number 355, which pertain to issuing the said communication dated 21/9/2021, there were certain overwritings, striking out, manipulation, etc. Accordingly, the Deputy Commissioner intended to cause an inquiry as to why there were manipulations in the issue register, and for the purpose required the presence of the writ petitioner along with necessary documents as may be required. But if the additional Deputy Commissioner along with the other officials required the presence of the petitioner with any relevant documents for the purpose of causing the aforesaid inquiry, the procedure to be adopted would necessarily have to be to issue a formal notice to the petitioner to appear before the office and not use the personal mobile phones of certain officers, whether or not threatening the petitioner to appear before them. It is also noticed that the additional Deputy Commissioner, upon verification of the issue register and upon analyzing the same, also made a statement that there is a possibility that the correction, manipulation, etc. in the issue register at serial 355 was caused by the dealing clerk who had made the entries, inasmuch as the entry that was struck out appeared to be not necessary to have been entered. And in fact, the entry regarding the communication dated 21/9/2021 would have been the more relevant entry to have been made. As the entire issue was a non-issue from the beginning, we do not intend to continue any further, but however, we also put on notice the government officials, especially against whom there is an allegation that he had threatened the petitioner over his personal mobile phone for appearance, that such method should not be adopted by any government official. And if there is any necessity of any citizen to appear before the authorities for the purpose of any inquiry, the more acceptable procedure under the law would be to issue a formal notice of such appearance. The concerned official who had adopted the method not recognized by law has understood the issue and has stated before the court that henceforth appropriate procedure will be followed, requiring any appearance of any citizen to be made before any official authority. In view of the above, the issue regarding the threatening is closed. The personal appearance of who is also present today stands dispensed with.
If they want to inquire, my lord, they can proceed, my lord. It
And
should be
we
as per
already
the law.
provided. We also add that if the authorities are of the view that any inquiry is required to be conducted regarding the manipulation, alleged manipulation in the issue register, the appropriate procedure of law as indicated above should only be followed and not any, should I observe, extra constitutional method that should be followed.
My lord, that original document-
List the writ petition accordingly.
Earlier date.
Accordingly.
My lord, after 3 weeks, and that's it.
List the writ petition after 3 weeks
And that
for its
original-
consideration on merit.
my lord, that document, can I, my lord, retain it, my lord?
The
Original
communication dated so produced by Mr. B. Gogoi, learned counsel appearing for the officials appearing before the court is returned back.
I am obliged.
And a photocopy thereof be kept on record.
Obliged.
Item 6.
And the writ petitioner is also put to a strict notice that unnecessary allegations against government officials should not also be made and to be avoided.
Obliged.
Don't go take the extreme steps straight away.
Obliged. It is your lordship. This matter relates to selection of assistant professor of the college.
Coming first time.
My lord, no, second time. My lord, instruction was directed to be obtained. Her grievance is that, my lord, perhaps her candidature has been rejected on the ground that she has done her PhD.
Something is there. Here,
Some instruction.
take it up this. Did you give him, Mr. Chaudhary?
I have,
Let him also. Who is the honorable advisor? One expression is there upon scrutiny by the honorable education minister, we understand, and the honorable advisor. Who is the advisor?
I think Noni Gopal Mohanto is
Sorry,
and Mohanto, Noni Gopal Mohanto.
advisor means
I thought, my lord, the government has taken an advisor in the education department.
Education
Mr.
department.
NG Mahanta, Nonigopal Mahanta is perhaps, my lord, to my knowledge, he is the advisor.
so. This is in your favor, I think.
It appears, my lord.
Huh.
But they are yet to take the final decision. The college has to say now why
It's regarding a selection.
it's
The
regarding
petitioner was rejected that the PhD is not acceptable.
PhD is not acceptable because she has done, although in the English, but it is from Guwahati University Foreign Language Department. On that ground, my lord, she has been rejected. That is her apprehension, my lord. So she filed a
No, but
representation.
if Guwahati University awards PhD in English from Foreign Language Department, how another authority can be aggrieved by that? It is for the university to decide. It is for the UGC to take a call whether you can do it or not.
The allegation of the
But once there is a valid degree given by a university, how third party can say that we don't recognize it? Otherwise also, what authority you have?
regarding
Being the appointing authority, you can put in a stringent condition that your in advertisement that PhD has to be from that department only, nowhere else. If you put it, you may have a prerogative. Then we'll examine the correctness of that condition. But otherwise,
Let him take the final. Let them take the
see,
final
no,
decision.
we are slightly more on it than taking a final decision. Why will you, on what ground will the college reject it?
perhaps
No,
yes.
just tell me. UGC consult. Print of type basically. You have the UGC Act with you, anybody?
In fact, my lord, that position is clarified by a Guwahati University notification, which I have annexed at page 66, my lord.
University can say something if they want, because UGC Act এখন আনি থৈ দিবচোন, repeatedly লাগি থাকে. Ask the library to provide one UGC Act. সদায় এখন হৈ থাকে. আছে নেকি তাতে? হ'ব পাৰে, সেইখনে দিছিল নেকি এখন? এনে বেয়াৰ এক্ট নাই নেকি UGC Act খনৰ? তেনেকুৱা নাই নেকি হালধীয়া এখন? কিয় নাই? Yes, this one issue came up, I think 2-3 days back in another writ petition.
Oh.
Section 22 UGC Act, the right of conferring or granting degree shall be exercised only by a university established. So that is the statutory power of a university. If the university grants a degree, how other extraneous authority can say we don't accept that degree? There is, I don't think you have any legal authority to reject a degree.
perhaps my lord,
Unless the university themselves, at the best, you can correspond with the university that please give us your views on this degree. If the university says it is unacceptable for this purpose, it's okay. But otherwise, you cannot form your own view. Tomorrow, our judgments also will say that I don't accept this one. Can you do it?
no. The selection committee, actually, my lord, the selection committee.
Selection committee will
Yes, ma'am.
only take note of the degrees and take their call. They have no authority to verify any degree.
Yes, my lord. That's why, my lord, the authority has asked the selection committee to explain, my lord, how he has been rejected as per this instruction. My lord.
Why should we wait for an instruction? We'll ask you to proceed with it.
Proceed with the
Selection.
So selection has already been made, my lord. Private respondent has been selected, but
But
no
say you were
appointment,
not there.
my lord.
You were not selected
I'm not selected.
because of this rejection.
This because of this rejection, and that is why, my lord, the matter is being verified by them. On the basis of my complaint, the appointment has been withheld. Appointment of the private respondent has been withheld.
Third, Mr. N.K. Choudhury, Learned Senior Counsel for the petitioner, Mr. S. Das for the respondents in the Higher Education Department.
Thanks for responding.
Mr. Anybody for UGC? Ms. So-and-so for the respondents in the UGC. Issue notice written over 6 weeks. Extra copies 3 days. Steps on respondents number 3, 4, 5. Registered post 3 days. The writ petitioner Dr. Kakoli Das offered their candidature pursuant to an advertisement dated
Advertisement 24/8/2022.
24/8/2022 issued by the respondent
Principal, my respondent number 4.
respondent SB Devra College, Ulubari, Guwahati, amongst others for a post of lecturer,
My lord. Assistant professor
for post of assistant professor
in
in
English.
the subject English. One of the essential requirements, one of the essential qualification requirements for the post was of a PhD degree in English from a recognized university. In furtherance of her candidature, the petitioner relied upon the PhD degree conferred upon her by the Guwahati University in the subject English. But as it happened, the petitioner had obtained a degree from an interdisciplinary department of the Guwahati University, namely the Foreign Language Department, and not the English department. The respondents of the SBD College had raised an objection on the acceptability of the degree of the PhD degree of the petitioner. For the purpose, communications had also been made to the Guwahati University, and the reply of the Guwahati University, page number.
My lord, the Guwahati University notification is at page 66, my lord.
And the reply of the Guwahati University.
My lord, that is not a reply as such, it's a notification.
This is not a reply, actually. I'm going to this issue. And the actual reply of the Guwahati University is still awaited. But what is noticed is that the PhD degree of a petitioner is a degree granted by the Guwahati University in due course, which is statutorily governed by Section 22 of the University Grants Act 1956. Once a degree is granted by a university, such degree under Section 22 of the UGC Act is understood to be valid and binding on all. And it is only for the university who had granted the degree to express any views on the acceptability of the same. Prima facie, it does not appear to us that a third party, being a selection committee of a college for which a selection process is initiated, would be an appropriate authority to raise any issue of unacceptability of a degree granted by a university. Even if it is so, it is for the authorities to take it up with the Guwahati University for their final view on the matter. And without such final view, degree cannot be rejected by authority. In view of the prima facie case made out, further selection pursuant to the advertisement dated shall remain state.
My lord, the earlier order was that, my lord, the appointment, no appointment should be made. That is
No,
the
no,
order.
stay everything. As on today, you stay everything. Maybe you will have to send this person back to the selection committee.
Highly obliged.
Item 7.
Yes, Mr. Patel.
These are the matters regarding the tea garden and ex-tea garden certificates which your lordship had passed certain detailed directions, your lordship.
You are for a medical course or
For the medical course.
your certificate will be placed before
Yes,
the committee.
one thing I just wanted to bring to your lordship's notice, in paragraph 33 of that order of 19/9/2023, the lordship has specifically directed that the state level committee should utilize the services of the district administration and
No,
preferably,
if required.
and preferably, and if required, the records from the tea garden management should be called for. Now, the procedure that they have adopted, your lordship, is that the students individually have been asked to go to each tea garden and get
Maybe we have not prevented them from doing.
But
We
your
only want
lordship.
the correct. If the student can go to the garden and collect the,
Yes.
that is also good enough.
Lordship, what
You
has
cooperate. Otherwise, if you 30 is over, you'll miss out.
Lordship, what has happened is, for example, in some tea gardens, when the students
And we also provided if a particular tea garden is not cooperating, bring it to our notice.
yes, your lordship,
Then we'll ensure that the tea garden does it. And not only that, we have made the labor commissioner also a part of the proceeding.
lordship,
Labor commissioner has control over the tea gardens.
yes.
Get it done.
What has happened, for example, in item number 8 also it's similar, your lordship. Just to bring it to your lordship notice, the tea garden in question, it has closed down in 1985, your lordship. And the education notice published by the authorities, your lordship, it specifically says that we need a certificate from the manager of the tea garden, your lordship. Now, that is the difficulty we
In response, if as a clarification of our earlier order dated so and so in WPC so and so, it is provided that the expression manager of the tea garden is to be read as any authority under of
Very
a
well.
tea garden, either existing or which earlier existed, and it is for any person associated with the tea garden to cooperate with the process. And for the purpose, the labor commissioner to the government of Assam shall do the needful.
very well.
We made it
Then-
broad-based.
Yes,
We want
education-
only one information. Did you work in a tea garden?
Yes.
Lordship, that
The
authority.
report is available.
Report is available. Inquiry is over, Lordship. Lordship, inquiry report.
No, his case, he says that he is having difficulty.
No, we have taken the service of the respective deputy commissioner as well as the circle officer as well
So
as
deputy commissioner can always go send anybody
circle officer.
for a look at the records of the tea garden.
Lordship, Lordship.
And every tea garden, existing or non-existing, the records are maintained somewhere or the other.
Somewhere or the other.
As on today, well, the report is here.
We accept the
That will
report.
be looked into. That-
Unless it is challenged by someone, we accept the report.
As per the report, there are 7 candidates. who have
So
been
his case was rejected, Mr. No, Mr. Pathak, who is your client?
There are two petitioners. One is Miss Chaini Bhuya.
Chinese.
Chaini Bhuya, that play. Chaini Bhuya is a very difficult customer.
No, both are rejected.
Rejected.
Chaini Bhuya has to be rejected because Noorbadi Tea Estate says that the Lolit Bhuya was not their employee. We remember to that extent.
And Vishaka Chandravanshi.
Huh.
Second one. In her case, your lordship, the garden is closed in 1985.
Huh.
And she has been asked to procure a certificate from the management. Which she has been unable to do.
Definitely, it is the Mr. Pathak. Section 106 of the Evidence Act will be applicable. You cannot throw the burden on somebody else. I made a statement, now you go on proving yourself. These are facts known to you. So Sandra Bansi knows who is her father, who is her grandfather, where he worked.
Yes, your lordship.
Okay.
Yes, your lordship.
And it is for them to go to that authority. And only thing we provided, if Sandra Bansi is prevented by any of the persons pertaining to that tea garden, then we have given enough power to the labor inspector and also to the deputy commissioner to take it forward.
Just one quote. Perhaps I'm not seeing the report. If it has been only rejected on this ground, I have not been able to get a specific certificate from the manager.
No, well, the report kindly see serial 6.
Serial number 6.
The second last column, report of circle officer, Nongao Circle, the revenue circle.
After verification of other documents submitted by the circle, it is found that neither the parents nor the ancestor worked or associated with any tea garden.
Then we'll have to challenge.
In respect of the candidate Vishakha Chandravanshi, an assertion has been made that the tea garden concerned had closed down in the year 1985. Even if the tea garden has closed down, the records thereof would definitely be available with some authority, who were either associated with the tea garden or with the Labor Department of the government of Assam. Full stop. The Deputy Commissioner Nogao may provide any aid as thought by the petitioner to get such record verified, if available. If available, because if nothing is available, from where do you produce it? There cannot be a negative order. And upon such exercise, in course of the day, if any further material is available, the same may be placed before the committee and the committee will give it a consideration. In course of the day, today only.
The tea garden claimed by the petitioner is in Kachar, not in Nogao.
Vishakha,
No, the relevant deputy commissioner, where the tea garden is located. Take this cell, go find out. And number one, the labor department has a record of every tea garden laborer, if I am not wrong.
Usually they have. Usually. And this second petitioner is at serial number 8.
Second one is not required.
second one.
Chinese.
No, this is
No, this is
Vishakha.
Raghuvanshi, not Raghuvanshi, what Vanshi? Chandravanshi.
Other one,
Chinese we are
we'll have
not
to challenge.
interested because Chinese we have already verified the records.
Yes. And the report suggests that other persons are also there. Those were not correct. The certificates are not found correct.
What to do? He's not correct.
Yeah, my lord, the liberty may be given to us so that the director of medical education can fill up this file. Now we can.
A report on the observations and findings of the state level committee upon examining the various applicants in the first year MBBS course under the TGL ex-TGL quota has been produced before the court. Except for the serial number Vishakha Chandravanshi as indicated above, the reports are accepted. The medical education department may fill up the TGL ex-TGL post through any other suitable candidate on merit who belongs to the category of TGL ex-TGL.
My lord, they have conducted inquiry of the BDS course also. 3 seats were there, all 3 have been found to be not genuine. So Lordship may indicate not only my lord MBBS as well as BDS.
MBBS, BDS.
I'm obliged.
Okay, my learned colleague can use his good office to inform the DC that we'll approach him during the
Yes,
court.
Mr. Please help. Because this is a different case, garden closed down. So if she wants to
We'll do
go
it
and
right
get
away.
some record verified, maintained by somebody, go and verify. Or the DC can also find out who was the owner of that garden. Make a phone call from them as to what happened to your records.
But we have no clue which is tea garden. If he gives me
Yes,
some
sir,
information, I
everything
can
is-
share.
The
I can share.
the petitioner to approach the office of the Deputy Commissioner Kachar for the purpose.
Along with the document.
Yes, whatever we have.
In course of the day itself, today itself.
Yes, sir.
Not later.
Yes, sir. No, but that is why I asked.
एक copy to the order तुम्हारी जो गेटिया sign कर
Very, very deeply obliged.
so no sign করে দিও কারণ he has to appear before. Mr. Nath, send a message that this person may go to him and he will cooperate. That's all. In the meantime, These petitions are pending or
In fact, notice has not been issued, still in the motion stage.
But these petitions may remain because ultimately the caste certificate lordship has to take a decision. What will happen? Now at this stage, admission has been lordship.
because something will happen by 30 this way or that way.
Correct. Now the
so what a presence to people.
lordship has taken care of the admission part, so the certificate part will come next. What will happen to that certificate?
It's no certificate in the eye of law for the TGL, ex-TGL.
Correct.
It will have to be cancelled.
Lordship.
It has to be cancelled.
Therefore, let the matter remain for some time.
Okay. Then we'll pass a more
Okay.
comprehensive. So what a presence to DGO. Huh? Okay. Report to Ghorai. Mr. Nath, Mr. Das have produced the report. The report produced is returned back to Mr. R.M. Das to be produced again on the next returnable date.
Item 9.
Last order, your lordship wanted to see the order of provincialization.
Pass over for the time being, but will appear.
This is a peculiar case. In 85, art stream was
Yes, yes,
provincialized. Science stream was not.
yes, yes.
Although science stream existed at that relevant point of time. It existed, I think.
Yeah, 95.
Or it existed in 95.
95.
So science stream will be a venture degree college or it will not be a
Yes,
venture
my
degree
lord has
college.
put a specific query in the last step, my lord. My lord, Mr. K. Gogo will appear, my lord. Yes.
Mr. Gogo will
Yes,
come.
yes.
Okay.
My lord, I got two documents. 1985, my lord, it was deficit system of deficit grant in aid, it was taken with salaries and all. And provincialization order was in the with effect from 2005.
Of the art stream.
Yes.
And that is,
Of the arts.
that is under which act?
Grant, my lord,
No, that
deficit-
provincialization
deficit-
is under which act?
Deficit in that act is not mentioned. But earlier, your lordship knows, but
Yes,
colleges
in,
were granted. And
in
the
2005, your
Order of
provincialization is under which act?
art section, that is 2005.
2005 act.
2005 act already.
2005.
And when was the provincialization made?
With effect from 2005.
No,
The
when?
year-
On the, where is the order of provincialization?
That is there, with order is dated 2007, February 2007, with effect from
2007.
2001-12-2005.
So this is a provincialization under the Act of 2005.
2005.
Art stream was provincialized.
Valid.
This act is still valid.
This act, my lord, now it is 2017, as your lordship knows.
No. We know 2017, but is 2005 still valid or it is repealed?
It must be repealed, my lord. I'll look into it. Hello, sir.
Find out in the 2011 Act. Maybe it was repealed by the 11 Act. Hey, Harikon Song, Provincialization Act 2011. Boro. 2011 Act, Provincialization.
Last up, sir. Last up, sir. Last two.
Did this one repeal any earlier act? Repeal, huh? Save answer venture educational. 2011 repealed.
In 2017, 2011 is repealed.
Did 2011 repeal the 2005 Act?
That I'm not finding it.
647
is a repeal provision to
2011 does not repeal anything.
doesn't repeal anything.
And 2017 repeals only 2011.
2011.
So 5 survives. then what will be the implication? Yes, Mr. Das, you are getting into more and more complicated situation. If Mr. Das,
Yes, my lord.
and if 2005 Act is for provincializing the colleges, Mr. Gogoi is also coming. Mr. Gogoi, these colleges are provincialized under the 2005 Act or under the 2017 Act?
Provincialized, the particular college was provincialized under the 2005 Act, Lordship.
As of now,
Lordship.
colleges are provincialized.
Lordship.
Forget about the petitioner
Lordship,
college.
Lordship.
It's under the 2005 Act or under the 2011 Act?
5 Act and 11 Act, those are the ventures, they are the 11 Act, Lordship, and those are the deficient granted age system of college, Lordship, that are under the 2005 Act.
If the college is deficit grants in aid,
Lordship.
it will be provincialized under the 2005 Act.
Lordship.
And if it is not deficit, but purely venture, then under the
Then 2011 Act. And
11 Act, repeat, now 2017.
Lordship.
So, Mr. Das, your college is deficit grants in aid college for the science stream.
No, only art stream.
No.
But what about the science stream? It is
Science stream, it was open in the year 1995. And they
no, is it a venture?
Science stream was a Lordship self-finance.
Sorry.
Science stream which was opened by the college, Lordship. It was a self-finance stream was by the college, Lordship.
So this same college
Lordship.
now we'll have to split into two parts.
Lordship.
Arts part will be granting aid.
Lordship.
So it's provincialization governed by 2005 Act.
Lordship.
Science stream will be a venture degree college.
Lordship.
It will be governed by the 2017 Act.
2017 11 Act, Lordship.
11 is gone now.
17
No,
Act,
as on today.
subject to fulfillment of the condition, Lordship.
Definitely.
Lordship. But here case is that, Lordship. The case is, because, Lordship, not only this college, Lordship, 7 colleges where earlier science stream is there, Lordship, their concurrence was not as per the, Lordship, 2017 Act. So, Lordship, government had created an additional science stream, Lordship, for that particular colleges, Lordship. And that,
Sorry, no, I have not understood.
Lordship.
What do you say? Last sentence, what do you say?
Lordship, the particular college, the MC.
No, just repeat the last sentence.
Last sentence, Lordship. Government had created, Lordship, additional science stream.
Additional science stream.
Stream, Lordship. Those colleges that where they are not fulfill the criteria laid down by the Lordship 2017 Act.
Okay, if they don't fulfill the criteria in the 17, they cannot be provincialized.
They cannot be provincialized.
So you have created a science stream.
Additional science stream.
Additional
science stream.
Science stream.
For 7 colleges.
7. So what will be the legal effect?
Legal
now they will
effect-
be considered under the 5 Act.
2005 Act and recruitment for the direct recruitment, Lordship. All the posts are created in 2019, Lordship.
So now you will consider them under the 2005 Act.
5 Act, Lordship. 5 Act.
So the irregular part of being a venture had now been removed.
Lordship.
And now they are regularized as grants in aid.
It's a, Lordship, new creation as a, Lordship, additional science stream, Lordship.
Anyway, so by virtue of this creation, now they will be within the 2005 Act.
2005 Act, Lordship. And the post.
So you consider them under the 5 Act? Pass your order.
They have to appear the interview, Lordship. It's a direct recruitment.
Everything.
Lordship. They will appear the interview. They are not considered.
Well, your lordship will kindly see section 3.
Mr. Das, can we issue notice? Let them reply.
Well, in the meantime, my lord, the push held by the petitioner should not be pinned up. In respect of the others, your lordship has already granted. In
Why?
respect of the others, because
No, let us list all the petitions together.
Lordship.
But in
Let us
respect of the others, your lordship will
list
kindly
along with
see.
WPC, Baki video,
Lordship.
where the interim order is there. We'll consider what kind of orders to be passed.
Page 95, my lord.
We'll list it along with that.
What I am showing, my lord, under the 2011 venture school.
Mr. Das, for the time being, we are trying to avoid the negative interim order. Don't do anything.
But only thing,
Mr. Das, we are trying to do what is possible for you. So that you are also benefited, college is also benefited, and others are benefited. A negative interim order is very easy to pass.
The date may be given.
We'll stay it After 5 years, we'll again ask Mr. Gogoi, yes, what is the matter about? And neither you are gaining, nor they are gaining.
That's all.
So-
Connected WPC, my lord.
In fact, Mr. Gogoi, you find a reply also.
Lordship.
4874.
We will try to, if necessary, pass a final order.
Lordship.
That will be better.
So whatever entitled they are, we'll try to analyze what they are entitled, considering them as per the entitlement.
Lordship.
Because you cannot go beyond the law.
Lordship.
So let us make an endeavor for
WPC
that.
4874 2023.
It will next date of DDO.
Lordship.
In the meantime, the respondents in the higher education department to also positively file their affidavit in opposition before the next return.
Lordship.
And a date will be
Next week? Next week?
Next week, Lordship. Interview going on.
Date you choose amongst us, whichever you want. We'll try to give a final hearing.
Lordship.
only thing, they should not finalize the interview which is going on.
Till the next hearing, a status quo be maintained.
Lordship.
Oblige.
Lordship. 10 days, even Lordship, then we can Lordship.
Mr. Nayak,
Lordship.
take it. Mr. Nayak, we wanted you for in that particular matter, I don't know the item number. There is a selection process, they claim, as per a communication of 2021. There is another process as per a communication of 2023. This is what the petitioner is trying to submit. We just want to know what happened to the process under the 2021. Whether it was abandoned, whether it was completed, whether it is pending and you intend to complete. Just specific answer. We are unable to get that. Perhaps that the council is also not understood or the director is not understood. I don't know. I have already ordered for the personal appearance for the director. We will only get for 1 day. Please bring us the information. What happened with the 2021 process? 3 possibilities there. It is completed. Second possibility, it is abandoned. We are not going ahead with that one. Now we are doing in an amalgamated manner under the 2023. Or else 2021, we are processing, yet to be completed, we are going to complete it. Meaning thereby 2023 will be on an exclusion from 2021. This simple information we want. So that
Lordship speaks this matter.
কোন একটা ডেট দিও এইটো নতুনকে দি দিওকচোন এইটো আগৰটো কেনসেল কৰি list on so and so for the information as to what is the outcome of the selection process initiated by the communication dated 2021 8/2/2021. That is whether the process had been completed or it has been abandoned or it is in process and would be completed within the agreement. Only 3 answers we want. Then we'll think what is to be done with him.
Lordship will take up this matter in the next week.
You take a date whenever it is convenient. Don't bring in directors giving all kind of complicated information, but not the basic information.
Lordship.
Don't bring any more information.
I will not.
Item 10.
Yes, item 10. This one is just to produce the result of the earlier.
Lordship, in this case, petitioner participated in a recruitment process, Lordship. Pursuant to advertisement dated 30.
Same whether it was completed or it was abandoned. Same order.
It has been abandoned.
Abandoned.
By notification dated 28/8/2023.
Where is that notification?
This.
Mr. Islam, we close this petition. We give you liberty to challenge that one if you want. If any of you are right pertain to the earlier selection and you are agreed by the abandoning it, you challenge it. We'll hear you. But this advertisement, we cannot interfere.
In the press advertisement, it has been specifically mentioned that it will be for female only.
You understand if there is that impugn order in notification advertisement, your lordship, page 30.
Page 13, yes.
Page 30, your lordship. The teachers push up for the female, your lordship.
Sorry.
Lordship. Page 30, your lordship.
Page 13 is a part of your writ petition.
Page 30.
Because your prayer is in page 17. So 13 has to be a part of the writ petition.
If you input advertisement, I have challenged.
Where is the advertisement?
Page 30, your lordship.
30.
I am reading that advertisement what they had said.
On what ground you are challenging?
No, I am saying, your lordship, because that earlier we have challenged that earlier we have participated, it was not published.
That's what, Mr. Islam. You may have participated, but they have produced a notification that that process was abandoned. So you challenge that one. If the abandoning is illegal, we'll interfere. But that does not mean we interfere with the next advertisement. Heard Mr. S. Islam, Learned Counsel for the petitioner, also heard Mr. P. Naik, Learned Counsel for the
SSA.
Respondents in the SSA.
I'm appearing for respondent number 1, second reading.
Das, P. Das for authorities in the secondary education department of the government of Assam. Who is Rufikul Alam Ahmed?
He is the district program officer.
We do not find the necessity of the respondent number 6 being implemented in person, and accordingly the said respondent stands deleted. We do not find any material justifying the area of respondent number 6 in person. Accordingly, how many petitioners?
One petitioner.
The petitioner participated in a selection process pursuant to an advertisement annexed as Annexure 3, page 27 to the writ petition. Before, according to the petitioner, before the results of the selection process in which he had participated could be declared, another advertisement available at page 30 to the writ petition was issued by the respondents in the SSA. The petitioner had instituted this writ petition on the grievance that without taking the earlier selection process to its logical end, a subsequent advertisement for the same purpose cannot be issued under the law. To verify the authenticity of the issue raised by the petitioner, we required the respondents in the SSA to provide the information to the court as to what had happened to the earlier selection process, which was initiated as per the advertisement. Which page it was? The advertisement at page 23, Annexure 3 to the writ petition. Mr. P. Naik, Learned Counsel for the respondents in the SSA, has produced a notification bearing number. Number to side, huh? Yes. Bearing number so and so dated 28/8/2023 of the District Mission Coordinator SSA South Salmara Mankachar, that a decision had been taken that all fresh engagement of teaching and non-teaching staff inside KGBVs bracket type 3 would be filled up only through eligible female candidates. It is stated that in view of such decision, the earlier selection process initiated by Annexure 3, page 827 advertisement had been abandoned by the authorities. As it is a stated stand of the respondent, the SSA, that the earlier selection process pursuant to the advertisement as Annexure 3, page 27 had been abandoned by referring to the notification dated 28/8/2023. We are of the view that in the writ petition in its present form, we do not notice any infirmity in the advertisement at page 30, which is assailed in this writ petition. But however, if the petitioner is aggrieved, the process of abandoning the earlier selection process by the advertisement at page 27 annex 3 may be assailed by the writ petitioner if so advised. Writ petition closed with the aforesaid liberty.
11,
Last occasion, Lordship was asked. He should notice, Lordship, but my learned friend was not present. I served the copy, Lordship, regarding the essentiality certificate for.
Which department?
Lordship, the National Medical Commission, Lordship, name is not
Respondent
reflected, but my
number
learned friend has served copy upon me.
Very well. Yes, Mr.
Lordship. That notice may be issued, Lordship, because
Even only notice.
Lordship at this
A.
stage.
Mujumdar, baki likhi dibo, or
DK Boydho, my
DK
lord.
Boydho for
NMC, my lord, respondent.
NMC, responding NMC, Madam Gayan for Union of India, Mr. Tovilar for Higher Education Department. Between you two, who? You're Tovilar, not Gayan. Any more respondents?
Lordship, for respondent number 5, Lordship, I think might be, maybe Lordship with the, my learned friend.
5, who is the 5?
The register Assam nurses, midwives and visitors.
Sorry?
Council, Lordship. The register Assam nurses.
Assam nurses?
Nurses, midwives and health visitors council, Lordship.
Kiba he to likhi ba sai kone respondent. Huh?
This will be my lord council, my lord.
Lordship,
Number 5. You are not representing. But kita likhibo respondent 5 register post 6. Extra published 3 days.
item 12,
Yeah, please, Your Lordship. My lord, this is regarding compassionate appointment, my lord. Impugned order page number 28, my lord.
Was it placed before DLC?
DLC rejected my case, my lord. Last paragraph.
What is the date of the DLC, Mr. Pegu? Page 28. What's a DLC?
DLC 5/10/2020.
As per the OM dated 1/6/2015, which clause, Mr. Pegu?
My lord?
Which clause of OM dated 1/6/2015?
My lord, clause 16, my lord, that says, my lord, he should be a measure. But at the time of consideration, my lord.
That is norms prevailing at the time of consideration.
My lord.
Go back. Third, Mr.
F.A. Lashkar. F.A. Lashkar.
F.A. Lashkar and Mr. Green Pegu, Deputy Commissioner Hailakandi, E. Das, Secondary Education Department. The father of the petitioner, Sarafuddin Chaudhary, who was an Arabic teacher in the NT Model High School, Kalachera, in the Hailakandi district, died in harness on 5/8/1998. And on his death, the mother of the petitioner made an application for compassionate appointment on 3/9/1998. But at that relevant point of time, the petitioner was a minor, and upon attaining majority, on 3/9/1998 also you are a major.
No, my lord.
He is not a minor. 18 years. Yes, sorry. And appointing attained majority, the petitioner made another application dated 9/6/2010. Both the applications, that is the one by the mother and one by the petitioner, were considered by the DLC of Hailakandi district in its meeting of 5/10/2021, but it was rejected by providing that At the time of submission of the application, the petitioner was a minor being aged 8 years, 7 months, 4 days. And therefore, as per the OM dated 1/6/2015, it stood rejected. Mr. G. Pegu, learned additional sitting and advocate for the Deputy Commissioner Hailakandi, clarifies that Clause 16 of the OM dated 1/6/2015 was relied upon for rejecting the application of petitioner, which provides that an applicant for compassionate appointment ought to be a major. It is noticed that there are two applications in the instant case, one by the mother on 3/9/98 when the petitioner was a minor, and another by the petitioner himself when he attained majority, and another by the petitioner on 9/6/2010 when he attained majority. In any view of the matter, as per the law laid down in para 35 of the judgment of the Supreme Court rendered in NC Santosh, the norms prevailing on the date of consideration would prevail, and on the date of consideration, that is 5/10/2021, it is an admitted position that the petitioner was a major. In such view of the matter, the rejection by the DLC in its meeting in respect of the application of the petitioner stands set aside, remanded back to the DLC for a fresh consideration to be placed before the placed in its next meeting. Consideration on merit under the law.
13.
Obligement.
Pleasure, Lordship.
Compassionate.
Appointment, Lordship.
DLC.
DLC, Lordship. Relevant page 36, Lordship.
36. Who is the petitioner?
Minnatullah
Mazumdar.
Serial number
Where
6.
is Minnatullah Mazumdar? Applicant, where is from? There is no vacancy in other departments also.
Lordship. But my case has been transferred from LP school teacher to grade 4, Lordship. Top, Lordship. Page 36, top, Lordship. The House also discussed the proposal in respect of 6 candidates under grade 4 category, as one of proposal by Srimati Romana Begum Loskar had been transferred from grade 4
Yes, why
category
is
to
it
LP
transferred?
category.
Low percentage, 33.8%.
Doesn't have the qualification.
I have 50%, Lordship, but as per betterment examination, Lordship, before the date of consideration, Lordship.
And
did you submit it?
Yes, Lordship, I have an
Where is your application that you have submitted your betterment marks?
application.
By
Lordship.
which communication you had made available the betterment marks?
Yes, Lordship.
Page number.
Lordship, I have not annexed
Then
the
how
application.
the DC is supposed to know that you have got some betterment marks if you don't inform the DC? If you don't lay your facts before the court, do we have any means to go to your office chamber and find out the facts?
No.
Same is with the DC. He is not expected to go to your residence and find out what betterment you have. It is you who should inform the DC with. If you did not inform, what can be done? Will issue notice? Heard Mr. N. petitioner. Notice 6 weeks, extra copies 3 days. The claim of the petitioner for compassionate appointment had been rejected by the DLC of Hailakandi district in its meeting of 7/5/2022 on the ground that the application of petitioner was considered against the grade 4 post, and it was found that there were no vacancies available in the education department where the father of the petitioner had worked, and nor in any other department. But Mr. N. Hussain, Learning Council petitioner, has raised an objection that the petitioner had applied for as an assistant teacher in LP school, but his application was transferred and considered as a grade 4, as an application for grade 4. Mr. Girin Pegu, learned additional sitting advocate, upon informed the court that the application of petitioner was not considered for a post of assistant teacher in as much as the petitioner did not have the requisite marks and he had only 33% in the qualifying examination. But Mr. Ran Hussain and counsel petitioner states that in the meantime, the petitioner had obtained the betterment marks.
Yes.
And his present marks is about 50%. About 50%. But it is also stated that the betterment marks obtained by the petitioner had not been communicated to the deputy commissioner. And accordingly, we have to understand that the deputy commissioner did not have any material before it to consider the application petitioner as a LP school teacher in the absence of the materials being forwarded by the petitioner to the deputy commissioner for the purpose. List after 6 weeks.
14.
See, after hearing, if we get something, they didn't get.
May I please your lordship? Lordship, this matter pertains to apportioned salary under the Assam Employees Pranam Act 2017, ma'am.
What a portion salary?
Apportioned salary, my lord.
Who is the petitioner, Lalchan?
Lalchan, yes, my lord.
Who is he?
He is the, my lord, he is serving as head teacher, my lord.
What do you mean by apportioned salary?
Apportioned salary, my lord, this instant petition which we have filed, my lord, impugning an order passed by the designated authority on 29/11/2022, wherein, my lord, allowance of 10% from the gross.
No, which page?
My lord, it comes to annexure 2, my lord.
Page
Annexure 2
26.
at running page 26, my lord. This is the
Khalilur Rahman, dependent father of Lalchan Mondal. What is wrong with this order?
My lord, here in this case, my lord, if my lord for the moment comes to annexure number 1, my lord, annexure number 1, that is the copy of the notice.
Mr. Firstly, tell us why this head teacher is not ready to look after his father.
He's ready to look after, my lord.
Then give it. Then why are you before the court?
He is ready to look after.
Why are you so hard up about 10 rupees here and there? What you'll have to pay your father? It is because your father, you are a head teacher, mind you. Had your father not educated you properly, you would not have been in this position. What do you lose by looking after your father and giving him 10% of your salary?
My lord,
I think it's a dismissed with cost.
no, my lord. Initially, my lord, in this matter.
I know you were raising some technical issue, but what is the core issue? This money is not given to anybody else. It is given to your father because of whom you are a head teacher.
My lord, here initially, my lord, father.
Okay, you argue. What is your case? Let us hear you. Fine.
My lord,
why have you challenged this? On what ground?
yes. Initially, my lord, the father used to stay with us, my lord. But later on, my lord, he filed this complaint before the designated authority.
Your behavior towards your father must be such that it is not conducive for him to live with you in the same house.
Hello.
Your behavior must be so obnoxious that it is not reasonably expected. Tell me which father will leave his son? The hurt of a father is always larger than that of a son, mind you. No father abandons a son. Sons abandon their father. That's universally true. So now what do you want to prove in your petition now? That your father is so bad a character that he went out of the house, you want to look after him, and he had scrupulously claimed under this Pranam Act. Are you trying to make that submission?
No, my lord, I'm not on that.
Then what is your submission?
My lord, initially, my lord, he was to stay with us, my lord. But later on, my lord, he went away from us. But still, my lord, we want him to be with us, so that, my lord, to look after his.
Under the Pranam Act, is there any provision similar to 125(4) of the CRPC?
Section 8 of that act, my lord.
Where is the act? Let us see.
I said down.
Pranam Act kon sound. Employee की Pranam Act. Pranam Act 2017.
2007.
Do you have the act with you, Mr.?
My lord, I have just downloaded. নাই তাতে নাথাকিব ডাউনলোড কৰিব লাগিব (10% is the maximum limit which can be apportioned by law.
See, how the father can live with a amount smaller than 10%, tell me. If a headmaster needs 100% to live, how do you expect the father to live with an amount of less than 10%?
Yes. And that is the maximum limit that has been given by the designated officer.
So it's but he is invoking that the father is not living with him. Let us see what is the
In fact, my lord, if your lordship finds the page 31, page 31, my lord, the father files a complaint against him, 145 proceeding drawn against him, saying that he wanted to take over the father's property also. There are allegations that the father, the petitioner and his wife, is 31.
So this is to certify that lovely Aktara Mondal, daughter of Latsan, is a bona fide student of our college.
No, page 30.
So you will educate your daughter, but abandon the
page
father.
31.
31. Going to 31.
Read that line. তেওঁৰ নিজ জমিত খেতি কৰিবলৈ যায় তেতিয়া হলে 4-5-6 নম্বৰ প্ৰতিপক্ষৰ প্ৰৰোচনাত বাকী প্ৰতিপক্ষগণে কিবা one line is not there কৰি হত্যা আৰু তেওঁৰ ঘৰত জুই লগাই দি হত্যা কৰি দৰখাস্তকাৰীৰ সকলো সা সম্পত্তি প্ৰতিপক্ষগণে আত্মসাৎ কৰিব বুলি ভাবুকি দিছে.
This is the allegation that father has given.
This
And
is the
how can
kind
we
of
expect that the
son
father
the
will
petitioner is.
My lord, but here, my lord,
how can the father expect that he will live with him?
The petitioner, my lord, has not committed such act. In here, my lord, all the respondents.
So you go one thing, you go and get that FIR post then if you have not done. How can a writ court decide whether you have done or you have not done? We don't have the means to decide it.
Yes, my lord.
See, I'm telling you, your father must be having also some property. Sons must be eyeing that property. Give it to us. Otherwise, we'll not look after you. Father is, till his death, he is unwilling to hand over the property because that is one of his security in life. So you drive away the father, go, you have land, go and enjoy yourself. Father under the law is entitled to at least 10%. He has made an application, got the 10%. Now you are agreed. Now, how do you expect the court to believe that this father will now go and live with this son?
My lord,
হত্যা আৰু তেওঁৰ ঘৰত জুই লগাই দি হত্যা কৰিব বুলি. Which father will go and live with that kind of a son?
So far, my lord, here.
And he alleges, my lord, that the father has filed this complaint because on the provocation of the daughters.
Yes.
Of the daughters, my lord, his sister.
Family itself doesn't deserve it.
If I may allow to show paragraph 2 of the repetition, my lord. The conduct of the petitioner, my lord, doesn't even, he has not even identified the respondent as his father. Lordship will kindly see paragraph 2 of the repetition. He doesn't describe the respondent number 10 as father.
How much cost? How much cost should be imposed for dismissing the petition?
My lord, I apologize on that part.
Pay a cost of 50,000.
No, my lord. I apologize. I respectfully apologize before your lordship, my lord.
We don't want your apology. We
Because-
were on that son
Because my
of
lord,
that father.
because my lord,
You as a council, we have nothing against you. Why should we take accept your apology?
so my lord, I may be allowed to.
The
withdraw
learned
this.
counsel, Mr. Das, we have nothing against him. He is only a learned lawyer who is represented. We are on that son. So why should we accept the apology of Mr. Das? This one time, Khalilur Rahman, who is an octogenarian person and is also the father of 4 sons and 3 daughters.
He doesn't say that he is his father.
That may be
See
a
the hatred.
mistake on my part, my
No,
lord.
Mr. Das,
while
this
drafting my lord.
indicates the hatred of this petitioner towards his father. Now, under what circumstance the court will accept the father to go and live with this son, who threatens him with murder, who threatens him that I'm going to burn your house, who does, in a pleading, who does not recognize him as his father. Now, which clause you are relying upon? You relied on clause 8.
Yes, my lord.
Section 8.
Yes, yes.
What does section 8 provide?
No, section not section 8, my lord.
Hmm.
First of all, my lord, here the notice was being served. But,
Forget about that notice. Now, which clause you are relying on?
my lord, we preferred an appeal, my lord. We preferred an appeal.
Appeal
impeding this-
before whom?
before
Under
the-
which provision?
Under provision of my lord.
Section 12.
Section 12. my lord.
Section 12.
Yes, sir.
See, the legislature has done a very good service to the old people by bringing this act.
Yes.
The section. Well, my lord, before the appellate authority, my lord. Now, in terms of the, my lord, as described here in
So,
this act,
who is
my
the
lord,
appellate authority?
is the Lower Assam Commissioner, my lord. He is the first appellate authority.
Lower Assam Commissioner, does the post exist as on today? Check up, Mr. Kaushik, possibly does not exist.
Does not exist now.
That power is now exercised by the secretary of some
Secretary.
department, I think, GAD or something.
ZAD.
Hmm.
But way back in in the month of May, my lord, we filed the appeal. So, my lord, that appeal was not been taken up, my lord, within the statutory
So,
time period.
your
for the
grievance is only that appeal has not been taken up.
appeal is not been taken up, my lord. That may be taken up, my lord. That is my.
But we'll give our observations also.
And my lord, so
We'll
far-
ask the appeal to be taken up, but we'll give our observations what has to be looked into.
Yes, my lord. But
Heard Mr. P. Das and counsel for the petitioner also heard Mr. Somehow this behavior, it's not very good for the society and it should not be encouraged. Also heard Mr. B. Gugoi for the finance department.
I'm for 6, 7, 8.
Mr. B. Kaushik for the
Yes, one was 6, 7, and 8.
education department, elementary education department, Mr. P. Saikia for
4 and 5.
for the deputy commissioner and other authorities under the government of Assam. The writ petitioner Lalchan Mondol is a headmaster. He is the head teacher of Saktola Khonar Pupar LP School. It is stated that the father of the writ petitioner, namely the respondent number 7, Khalilur Rahman, was earlier residing with him, but later on shifted out of the residence of the writ petitioner and in turn claimed for the benefits under section 8 of the Assam Employees Parent Responsibility and Norms for Accountability and Monitoring Act 2017. In short, referred as Pranam Act 2017. Pursuant whereto, the District Elementary Education Officer, who is the designated authority under the Pranam Act, had passed the order dated 29/11/2020, requiring the petitioner to pay 10% of his gross monthly pay to the respondent number 10, Khalilur Rahman. The preamble of the Pranam Act 2017 itself provides that the act had been promulgated taking note of the respect and service to one's parents, taking note that respect and service to one's parents is the central obligation of children, which is an integral part of the Indian family system for ages. And that the emerging modern society with increased mobility and growth of nuclear families, the instances of negligence of parents by their children have of late come to exist, rekindling the family values, full stop. Accordingly, the act was promulgated with the purpose to provide for an enforceable morality through certain norms amongst the employees who neglect their dependent parents and divyang siblings, so that each and every employee would lead as a role model in the society. The petitioner, being agreed by the order dated 29/11/2020, had also instituted an appeal under section 12 of the Pranam Act 2017 before the lower Commissioner, Lower Assam Division. In the writ petition, the petitioner raises two grievances. Firstly, that the respondent number 7, number 10, had voluntarily left the residence of the petitioner, although he is all along willing to look after his father. And secondly, the appeal that had been filed before the appellate authority had not been given its consideration. Regarding the first grievance raised by the petitioner, that he is willing to look after his father, and also by requiring him to reside along with him in his own residence, we have taken note that the respondent number 7, number 10, Khalilur Rahman, who is the father of the petitioner, had filed a criminal petition before the executive magistrate Gwalpara, wherein, in respect of a plot of land owned by the father, there is an allegation that the petitioner and the other siblings had threatened the father of being murdered and other dire consequences, full stop. Without going into the veracity of such allegation, if there is an allegation by a father that the son is threatening him with murder and other dire consequences, it cannot be expected that the said father would feel comfortable and go and reside with the son in the same residence. Prima facie, we do not find any material to support the case of the petitioner that although he is willing to have his father in his own residence. Last sentence. The father is voluntarily not going and residing with him. From such point of view, we do not notice any infirmity in the order of the designated authority allowing 10% of the gross salary of the petitioner in favor of his father. But however, it is on the second ground that the petitioner had filed. We also take note of the conduct and attitude of the petitioner by referring to paragraph 2 of the writ petition, wherein the respondent number 10 is described to be an octogenarian and the father of 4 sons and 3 daughters, where the petitioner does not even have the minimum courtesy of recognizing the respondent number 10 as his father. The state approach also gives an indication of the mental approach of the petitioner towards his father, having bearing on the stand of the petitioner that he is willing to take back his father for residing along with him. Regarding the appeal filed, on the second ground that the petitioner has filed an appeal under section 12 of the Pranam Act 2017, it is taken note of that although the appeal was filed before the Commissioner Lower Assam Division, but it is stated that the state authority no longer exists, and the powers which were earlier exercised by the Commissioner Lower Assam Division is now being exercised by the Secretary to the Government of Assam in the General Administrative Department. Accordingly, the appeal of the appeal filed a petitioner under section 12 may now be entertained by the General Administrative Department, taking note of the facts as noticed and indicated above. Repetition.
Press appeal will be filed. He may file a press appeal.
No, it has to be filed within 1 month.
Oh, yes. For disposal, there is a time limit. For
No, it has to be filed within 1 month. Section 12.
Yes.
So therefore, let the same appeal be. Writ petition partially allowed on the second ground of the appeal being pending, but rejected on the first ground that the petitioner is willing to take back his father.
Lovely.
এটা চলা নাই নেকি? Yes, Mr.
May it please your lordship. SLC rejected lordship.
Where is DLC?
DLC lordship page 26. Relevant page 26. Serial number 5 lordship.
Sorry, serial number 5.
5. District Elementary Education Officer, Sonitpur. My name appeared serial number 3.
And where is SLC?
SLC lordship.
Page 34.
Page 38 lordship.
38.
Page 38.
Second table number, the number 1.
Second table. Page 38, second table.
Insufficient qualification. What is your qualification?
Higher secondary.
What is the required qualification for assistant teacher?
At that time, lordship, higher secondary.
Not that time. On the day it was considered. What is the
They have
qualification?
considered lordship higher secondary with 50% mark.
Do we have 50%?
No lordship, 40%.
Then how can you become a teacher?
Lordship may be considered other.
Heard Mr. N. Hussain, like also heard Mr. The father of the petitioner, namely Loghona Ram Boro, was serving as the headmaster of Bor Bhagia Balika LP School in the Sonitpur district, died in harness on 26/5/2005. And on his death, the petitioner submitted an application for compassionate appointment on 11/9/2005. The said application was considered by the DLC of Sonitpur district in its meeting of 21/3/2015. And the petitioner was recommended for a post of assistant teacher in a LP school. When the recommendation was placed before the SLC in its meeting of 27/2017, it stood rejected by providing the reason that the petitioner had insufficient qualification, insufficient percentage in the qualification examination. It is stated that by qualification, the petitioner had obtained 40% marks in the higher secondary examination, whereas according to the respondents, the required qualification for the post of assistant teacher in a LP school on the date when the consideration was made by the SLC, it was higher secondary with 50%. From such point, we also take note of the provisions of the law laid down by the Supreme Court in NC Santos, reported in so-and-so, wherein in paragraph 35, it had been provided that the norms prevailing on the date of consideration would prevail. Norms prevailing on the date of consideration would be the relevant factor for a compassionate appointment. From such point of view, we do not notice any infirmity in the rejection of the claim of the petitioner for compassionate appointment by the SLC. But however, under the law, that an applicant has to be considered against any available vacant post for which the applicant may be qualified for. From such point of view, the matter stands remanded back to the DLC of Sonitpur district to consider the application or a petitioner for compassionate appointment against any vacant post, if available, for which the petitioner may be qualified for, to be placed before the next available DLC of Sonitpur district.
16.
First time it is discussed. Here, my lord, what is happened, my lord, actually petitioner, my lord, challenge the selection and appointment of, my lord, the principal of Dorguma High Secondary College, my lord. Here, my lord, what is happened, my lord, at the time of submission of records, my lord, there was no PhD of the, my lord, principal, my lord. He was underqualified. But subsequently, after 7 months, this stone, my lord, as he has obtained PhD, my lord. So, and my lord, effect of the provincialization order was.
What is your prayer, Mr. Das?
My prayer is, my lord, this, my lord, his effect of provincialization order was, my lord, from 27/8.
No, your prayer is
yes,
to interfere with some order of recovery of illegal drawal of salary.
That is also, my lord, because my lord,
that is not also. That is the only prayer. Take a look. Is 16 and 17.
Yes, ma'am.
There is no other prayer. What you have
Quaranto is
already
also
stated.
there, my lord. Quaranto on what basis, my lord?
What co-warranto? What is co-warranto?
On what basis, my lord, he is holding the post, my lord?
Who is holding?
The principal of the said college, my lord.
Why? Why co-warranto? What is the co-warranto rate? Under what circumstance co-warranto is issued?
According to me, my lord.
Not according to you. According to law, what is co-warranto?
Yes, my lord. Well, under what authority he is holding the post, my lord?
Under what authority?
Yes, my lord.
Why he does not have the authority?
Because, my lord, PhD is not, my lord,
but that is will be a case of irregular or illegal selection, yes, rather than co-warranto.
Yes, yes.
So co-warranto is not maintainable. Co-warranto is something totally different.
Yes, my lord. Along with this amount also, my lord, because my lord, effect was from my lord, effect that was my lord.
So why do you challenge respondent number 7? Because of his PhD.
Yes, my lord.
What is wrong with his PhD?
PhD, my lord, without taking leave, my lord, from the college, my lord. He has obtained.
Where is the law that if you do PhD without taking leave, the degree is invalid?
Your lordship, hold my lord, in another case, my lord. I have seen, my lord.
Let us see what we have held.
In that case also, my lord. UGC provision, my lord, is there, my lord.
Which paragraph? Which paragraph here?
Paragraph, my lord.
You cannot go on to and fro again.
Yes.
You should have list again on so and so. Yes, next page.
UGC provision is there, my lord. And my lord, at
What UGC provision is there?
my lord, person has to take leave, my lord, for doing that PhD.
Where is
by
the
attending
where is the
classes.
UGC provision?
Next, on the next day, my lord, I'll
On
place,
the
my lord.
next step. Okay.
17.
My lord, the petitioners are headmasters, in charge headmasters and of the ME school, my lord. They are basically, my lord, agreed by the non-issuance of the order, page number 16, my lord, the clause 3, by the follow-up order by the department. With regard to their
Page
power.
number 16.
Page 16, clause 3, my lord.
They are headmaster.
Yeah,
So why have we agreed with this clause?
because they had as not agreement. This is not implemented. This, though it is decided by the department, but the follow-up order has not been issued.
That is for them to implement their decisions. How can somebody compel the government to implement? See, these are provisions of internal arrangement, how they'll run their administration. It is their prerogative on which they implement their decision. Or they don't want to implement their decision. How can the court compel them to implement it?
Petitioners filed by humble submission, my lord,
This
petitioner will
is-
file a fresh representation before the authority. They are on the
That you can
and then my lord, that they will take a
No, we not observe anything. Every
All on
citizen has right to make representation whenever he feels like. But that cannot be on the basis of support of a court order. You find?
notice may be issued at this stage.
Why? Your client will be happy, I know. Mr. Porokasto can respond better to his client. But why? What will he decide? By admitting, issuing notice, what will you decide? Nothing to be decided. This may be a very good decision, but it is for them whether they want to implement or they. The petitioners who claim themselves to be in charge headmasters of the respective schools have instituted this writ petition, seeking for a direction to the respondents in the secondary, in the elementary education department. Implement clause 3, implement clause capital A bracket small 3 of the decisions contained in the minutes of the review meeting of the education department held on 17/7/2022, which is extracted as below. The said clause appeared to be some kind of a decision taken by the authorities to be implemented, but the same apparently appears to have not yet been implemented. It is always the prerogative of the administrative authority as to whether to implement any of the decision or when to implement such decision. And it would be inappropriate for a court of law to direct the administrative authorities to implement any of their decisions which may pertain to an internal arrangement of running the administration, rather than any legal right being created in favor of any of the citizens. From such point of view, we do not find the writ petition to be maintainable in the present form. Writ petition closed. However, liberty remains with the petitioner to avail any other remedy if so advised. It will be very bad from tomorrow. Then courts will start dictating what to do, what not to do. Unless, of course, somebody's legal right is violated, then it will be a totally different situation. Item 18.
18.
Yes, Mr. Borua, what is this?
18. 18.
Petitioner before your lordship is a deputy librarian of the Agricultural University, Tezpur. And there is one post. He is a
Agriculture University,
Agriculture University.
Tezpur.
Yes. Jorhat.
Jorhat.
And one post of the chief librarian. Post was vacant since 2018. That is a post which should be filled up by the direct recruitment. One person who is taking the in charge of that post from 2018 without having requisite qualification to hold that post.
Oh, he is in charge.
Yes, in charge, but he has no requisite qualification for the holder. And the petitioner is qualified, but he could not get
petitioner is a person who is employed, or he is a unemployed person.
Yes. I am the 100% deputy registrar. Deputy librarian.
Who prayed for quo warranto 2 matters back?
Yes.
Somebody, I think, made a prayer for writ of quo warranto some 1 or 2 matters back.
Yes.
Who was it?
Yes, please.
Must have gone by now.
Huh?
I think this is a case of quo warranto. This will be a case of quo warranto. Why do you say he is ineligible? Why do you say the person holding the post is ineligible?
Yes, he is a person. I have specifically stated what qualification he has possessed.
No, don't make it so long. Give a short answer. Why do you say he is not eligible?
He has a not requisite qualification.
What is the requisite qualification? What qualification?
Fine. Page 21, 20, page 22. Page 22.
Mr. Purva, why are you always after pages? Tell us orally. What is the required qualification and what qualification this man has?
The person who have to post the chief librarian post must have a bachelor degree in study and the field of library.
Bachelor degree in
master degree in the field of library information science and recognized university.
Go a little slow. Bachelor degree in
any field of study.
Sorry?
And a master degree of library.
We have not understood what you are saying.
Essential qualification.
Yes.
Master
all of lahel hai koksun mane buji poa ke degree of what?
Speak a little the person holding the post. Master degree in library and information science.
Master degree in library and information science. That is the required qualification. This man does not have.
Does not have.
Who appears for Assam Agriculture University? You are appearing. Why are you allowing a man who is not qualified to be?
Instruction regarding this, Lordship.
No, you instruction, you file your affidavit, we stay it in the meantime. Because ineligible person cannot hold such a responsible post. Heard Mr. P.P. Burwal and counsel for the petitioner, also heard
MDB.
MS MDB for the respondents in the Assam Agriculture University. and Mr. K. Gogoi for the respondents in the Higher Education Department of the Government of Assam. The respondent number 5, Dr. Chandan Hazarika, by which order he was made the in charge? By which order he was made the in charge?
Yes. He has recently given this charge. He was a professor of agri-economics.
Sir.
Mr. Borua, if we have to help you, you will also have to help us. By which order he was made the in charge? List again on so and so. Come prepared. We can't waste time like this. This was some salary order.
Yes.
By which order he was made the in charge librarian?
We are stating that.
That is your statement. Where is the order?
That order.
কি করলো? No, everyone লিখিব নালাগে. Mr. PP Borua, edition লিখি দিব. The petitioner asserts the arrangement by which the respondent number 5, Dr. Chandan Hazarika, had also been allowed to be the in-charge chief librarian of the university on the ground that the person concerned does not have the required qualification to be appointed as a chief librarian. But the petitioner is unable to produce the order by which the respondent number 5 had been allowed to be the in-charge chief librarian. Respondents in the Agriculture University to produce the said order on the next returnable date, list on so and so.
19.
The respondents to also inform the court as to what is the required qualification for the post of chief librarian.
Yes.
And further as to what qualification the respondent number 5 do possess.
Lordship,
List on.
extra copy may be served, Lord. Right.
Give it. List on. Next week did you?
Lordship has issued notice.
We received. No, notice issue. No, we have received to your.
If you don't give copy, she'll also get instruction.
We'll give. No problem.
Your matter will keep pending.
We'll give. No, if you will find a notice, then
Notice. No, will for motion next week it will be listed. Because your case demands a more comprehensive interim order, so we want the information. It can't be passed today. Yes, Mr. Kakari.
Please, Lordship. My humble prayer before your Lordship to withdraw the case. We have already fulfilled our grievances by another writ petition, Lordship.
We don't record anything. Mr. Bipul Khaklari, Land Council petitioner, states that there is an instruction not to proceed this writ petition in the present form. In view of such statement, writ petition stands closed.
20.
May I please?
Yes,
petitioner submitted an application, my lord, on 15/10/2013
for what?
compassionate appointment, my lord.
For what?
For compassionate appointment, my lord.
Acha, it's not considered.
Not placed before the DLC.
Heard Mr. D. Bhuya, Land Council for the same order, if not placed.
If not placed, my lord. Otherwise, the application was given to the DEO, whether it was placed before the DLC or not. Let that.
We pass
My lord.
এইটো প্ৰথমে লিখি দিবা ডাইট অন সো এণ্ড সো অমুক অমুক এপ্লিকেশন মেড অন
made on 15/10/2013
grievance raised that not being placed before the DLC, which is the requirement under the law. Direction to the DO to place it next available DLC of which district?
District Dhemaji, my lord.
Dhemaji. If already placed, to inform the petitioner of the outcome, and in that event, no requirement to place it any further. Yes.
Highly appreciated.
21.
May I please, Your Lordship? Petitioner approached before Your Lordship for appointment offer only some Lordship. So I may be allowed to withdraw with a liberty to file a fresh motion.
Withdraw. Mr. Nazir Hussain and Council petition states that this petition, that there are some inherent defects in the writ petition and therefore the petitioner do not intend to pursue the same with liberty to file a fresh. Both prayers granted, writ petition closed on being not pressed, liberty granted. As prayed for.
22.
Yes, Mr.
May I please, Your Lordship? Lordship, matter pertains to compassionate appointment, my lord. DLC rejection
DLC.
at DLC is the page 35, my lord.
35.
Serial number 14, my lord. Down below. Page 35, serial 14, my lord. Petitioner is Dolly Devi, my
Dolly Devi.
my lord.
DLC what? Allowed or rejected?
My lord, rejected on the ground of time
As
barred,
the
my lord.
time of death or deceased is so and so. Yes, Mr. Saike.
My lord.
How do you respond?
My lord. Which I have raised, my lord, for occasion it has.
See,
yes,
Mr.
my lord.
Saike,
My lord.
every time you reject, we always have an answer. Here also there is an answer. Send it back. That's why I told you once. And in some cases, we have not even passed any order. Consider them on inter-se financial comparison. That's all. Don't bring the technicalities of civil law into this compassionate appointment. If you do that, the only impression we get is that there is a pre-selection. You select one man that this is the person whom we are going to give. The rest you find out reasons to reject them. It appears so by reading all your different DLCs. Best is, why don't you go to the core issue, make a financial comparison. Whosoever is the worst off, give it to that man.
Now, my lord, that principles we are trying.
Your officers are good. They're good in finding reasons. That is reason for rejection without doing the core requirement. Core requirement to do it. Third, Mr. The father of the petitioner,
My lord, husband, my lord.
the husband of the petitioner, who was the husband of the petition, namely Munindo Sharma, who was the head teacher at Septi Lower Primary School in the Kamrup district, died in harness on 14/11/2001. And on his death, the petitioner submitted an application for compassionate appointment on which date?
My lord, 5/2/2002, my lord.
5/2/2002. The said application was considered by the DLC of Kamrup district in its meeting of 25/10/2021 and rejected the same by providing as extracted, page 36. A reading of the reasoning of the DLC makes it discernible that the DLC, having taken note that the deceased died on 14/11/2001, deemed it appropriate that the claim of the petitioner would be covered by the OM number ABP 357-80-137 dated 9/9/1983. And therefore, rejected it by relying upon certain provisions in the said OM of 9/9/1983. But the law in this respect has been settled by the Supreme Court in para 35 of NC clause, wherein it is stated that the norms prevailing on the date of consideration shall govern the field, and as on 25/10/2021, when the application was considered, the norms provided by the OM dated 9/9/1983 was not in force. In view of the above, remanded back to the DLC for a fresh consideration under the law by taking note of the norms prevailing on the date of consideration. But however, the petitioner also has to file an explanation before the DLC as to the financial status of the family from the date of death, that is 14/11/2001, up to the present when it would be considered, meaning thereby that under what circumstance, in what manner the petitioner, family of the petitioner survived the aforesaid 23 years.
Pencil papers.
Moment you file, you are not entitled to compassionate appointment. The whatever reasoning is given by the petitioner shall be taken note of while making any inter-se financial comparison.
Deeply obliged.
To be placed before them.
Item 23.
Yes, Mr. Bhuya.
My lord.
Compassionate appointment. DLC.
Not placed before the DLC field.
Give the particulars, name of
my
the
lord,
father, when he died, date of the application, and same order.
DO. Or I will go to the
DO.
DO will place before the LC.
Ha. DO. District. District.
District Hemaji, my lord. Applied on 12/4/2004.
Please give him the particulars.
24.
Sir, please, Your Lordship. My lord, this is also compassionate appointment. My lord. Page 38 is the my lord, this district committee.
38 is the rejection.
Direction. My lord, the father of the petitioner was serving as grade 4 employee. My lord. And he applied for grade 3
His
post.
proposal was earlier placed.
He doesn't have the requisite my lord qualification. He's having less than 50% in higher secondary. That's why my lord could not be considered earlier by the district level committee. So now, because of perhaps want of vacancy, my lord, they could not consider me. My prayer before your lordship, my lord, that he may be adjusted in any other department.
On what grounds should I interfere? Your prayer we understand. Ground?
Look, since the vacancy
See,
is not
every
available
time-
in grade 4 post, my lord.
Mr.
Now I'm
Hamad,
praying-
every time we are finding out the ground.
Yes, my lord.
Let us know the ground from you.
Yes, my lord. My lord, I applied for grade 3 post, my lord. Since I am not qualified for grade 3 post, my lord, now I am praying before your lordship that my case may be kindly be considered in grade 4 post.
Yes, Mr. Saikia, what do you say?
That consideration, my lord, get purpose already there, my lord.
Mhm.
Get purpose consideration is already there, my lord.
In the same department.
Where did you consider grade 4? Not consider.
In any.
But recommended my lord, exhausted in page number 39, my lord. In that purpose, my lord. We start from page number 38, my lord. Get for consideration is already given, my lord.
Where? Page number?
Page number, my lord, 39. It starts from 38, my lord.
Exhausted in the same department, but I'm praying for any other department.
Any other department?
That has not been considered.
Mr. Dedham, I don't want. The father of the petitioner, Jugen Chandra Das, who was a grade 4 employee in the Sri Nursing Hastan ME School, Amtola, in the Hojai district. Hojai district is nowadays holding the field, or it is again remerged with
No, Hojai
It is independent. But sometime back, Hojai was again merged with Nogao.
Now, my lord, it existed again.
Initially separated, but later on somebody said that it was again merged with Nogao.
Like this one.
So presently it is Nogao or it is Hojai?
Presently Hojai.
How? Again separated.
Again separated.
Few months became Nogao. Now it is back to Hojai.
Like this one also, my lord, the same thing.
কি কলো, in the Hojai district. কি কলো?
Lord, father is Paras.
The Hojai district died in harness on 3/3/2016, and on his death, the petitioner submitted an application for compassionate appointment on 17/11/2016. The said application was considered by the DLC of Nagaon/Hojai district in its meetings of 14/12/2016 and 15/5/2017 for a grade 4 post of assistant teacher, but no recommendation was made for want of vacancy. It was again considered by the DLC of which district?
Nogao district.
Nogao district in its meeting of 14/2/2022, but again it stood rejected. After considering the application against any other vacant post in the education department by providing that no such vacancy exists. But however, it is taken note of that under clause 15 of the OM dated 1/6/2015, there is also a requirement of the department where the deceased was working to take up with other departments on the question of availability of any vacancy, and if the other department corresponds back by providing that some vacancies are available, there is a requirement under the law to consider against such vacancies as may be indicated. Accordingly, the district elementary education officer Hojai Nogao is directed to correspond with all other administrative departments in the district to find out as to whether any vacancy is available, and if available, to place the same before the next available DLC of Nogao or Hojai?
Nogao.
Of Nogao district.
Lord, the father of the petitioner is Parasnath Prasad.
Huh?
Parasnath Prasad.
You said Jogen?
No, Parasnath Prasad.
We wrongly read it.
Wrongly is written.
No, did I read in an incorrect manner?
Is Parasnath Prasad in the course title also, my lord, I have mentioned on the page.
Sorry. You read para 2. Read paragraph 2 of your petition.
There are two of them.
Your petition.
Page number 7.
I think we have rightly stated Jogen Chandra Das.
Oh, my lord, that was wrongly written. I'm sorry.
Sorry.
It was
It's your mistake, not our mistake. Number 1. Number 2, writ petition. Actual writ petition is the writ petition, not the cause title.
Yes, my lord.
Because cause title is not supported by any affidavit.
I apologize. But
Can you correct it?
Parasnath Prasad. Father.
नाम तो ठीक है लिखे हुआ और you correct this thing.
I live. Sorry.
Item 25 for admission.
May I please, Lordship? Already matter is part hearing, Lordship.
Oh, that matters. That child. I think two learned counsel.
Lordship, I have a call for the victim mother. She told me earlier when father was they told me that they look after the child nearby school, Lordship.
No, nearby school you will get.
Under their mother supervision, Lordship.
So do you need any order, any further order, or you don't need? That 3 lakhs or something the government will pay. I think Mr. Nath had agreed to that.
Lordship.
And do you need any more, anything more do you want?
Earlier, previous order, Lordship, government have given 4,000 per month, including child and victim, Lordship.
4,000 per month? No, no, no. To that victim mother.
Victim mother.
What about the child?
No, victim and child.
No, no. We are conducting this proceeding for quite some time now.
Lordship.
Presently, what you are getting? Presently, what is being provided?
Presently, no, not providing. After
Nothing.
Nothing, Lordship. Earlier, we have received 3 lakhs rupees, Lordship.
3 lakhs rupees under that victim fund. Under 357A.
Legal authority.
No, that is under 357A of the CRPC.
Lordship.
That's the only amount you have received.
Lordship.
Ask Mr. Dina to come. He was saying something that they will provide. Is Dr. Ashok Saraf available? I think last date he was here. Mr. Just check up if Dr. Saraf is available somewhere nearby and he is free. Please wait for some time.
Lordship.
26, 27.
If I made a mention in the morning,
Who made a mention in the morning?
he made a mention in
We rejected it.
with the consent of the other side, he made the mention.
MH law score praised for 4 weeks time to file affidavit. That was the last order. Have you filed your affidavit?
Not your Lordship. In the meantime, some development has taken place. What happened? Both the petitioner and the respondent number 5 are claiming for the post of postgraduate teacher. Initially, appointment was given in her favor. I made a challenge. The matter was remanded back to the director. The director took a fresh consideration of the matter and cancelled her appointment and given it to me. Then she filed another writ petition, which is now the pending one. And in that, your Lordship.
No, this is writ petition or review?
Writ petition
Both
as well
numbers
as
are
review
there.
matter.
How can it be as well as? Either it is a writ or a review.
He filed 2 writ petition.
Okay, against
First
one
writ
of his
petition,
writ petition.
we have not received any, but they also not.
So against one of his writ petition, it is a review.
Yes, my lord.
And there is one independent writ petition from your side.
He filed 2 writ petition without informing, but without stating in the earlier writ petition, same cause of action.
So now what is to be done?
No, Lordship, in the meantime.
Let us hear it. Let us hear both the petitions.
Lordship may fix it after the puja vacation, your Lordship.
After puja vacation.
If he has no objection.
My senior, my lord, appear, but he is ready, my lord, at 2, my lord, if possible.
At 2. Is he around? No.
My lord, at 1 date.
Today, my lord, Dr. Saraf is not available in court.
Oh, he is not here.
Also informed tomorrow he may appear, my lord. He said that tomorrow I can.
He said tomorrow he'll be available. Hey, to list tomorrow. Mr. Khaklari, tomorrow. No, because it appears the government schemes are not there. So we are trying to explore because some NGOs, etc. are there who sometimes provide this kind of financial aid. We requested Dr. Saraf to look into that, whether somebody is available. If it is available, maybe this education of the child can be taken care of. You are aware of the case, what it is?
My lord. Then tomorrow, my lord.
It's a case of a POXO violence
My lord.
where the mother is 10-year-old, gave birth to a child. Now our problem is the child. Earlier, the father of the victim girl was taking care. Now he also died during the pendency of this petition. So if we can get some aid from the private sector, that one who is ready to bear some educational expenses, we are going to put it. That's all. If anybody knows, anybody knows any private sector who may give some kind of an aid? Are you aware of any private sector who can give some aid for educating a child who is the offspring of a POCSO violence where the mother is 10-year-old?
There are so many NGOs are there. We can approach lots.
So we are asking openly, if any private sector is there, we can put and comes forward to an affidavit, we can place it in our order, the educational expenses of the child.
That can be
Because the mother herself has to be taken care of. Father is also no more. He died during the
for
pregnancy.
education lordship. There are
Sorry.
many, I can talk to some organization.
There are a lot of these voluntary
Yes.
private organizations.
Yes,
if somebody, we can have that information and they come forward.
Some individual people are there.
Because
there
state possibly doesn't have any such scheme.
Lordship,
Except that 357A of the CRPC, that victim fund.
No, I can explore. Lordship.
That victim fund is again given to the mother. What about that child? Father is in jail. He is convicted.
For education expenses, lordship, I can.
Only for that much. The rest will be taken care of.
Lordship.
Education of the child.
Lordship, that can be.
So last date we request Dr. Saraf. Today he says not unavailable. So we're placing it tomorrow. If Dr. Saraf has some information, he can
I'll be there.
tell us also.
I'll be there.
Thank you.
Lovely.
Yes, some other day. As per for list on so and so.
28.
Yes, Mr. Rashid.
She is getting one advance increment regarding
Respondents to produce the notice that may be given prior to the order dated 1610.
Yes, madam. In this way, the notice has not been issued.
Where is the order of 1610, 2021?
1610. Next, sir. Page 52 million.
52.
Annex 8.
What is ST? Science teacher. ST stroke 80.
80 assistant teacher, not science.
No, what is ST?
Yes, T million. It is a science teacher.
Science teacher.
80 assistant teacher.
So if you have not given notice, we have to interfere with it. Because whatever, rightly or wrongly, if you have given them one increment, later on you find they are not entitled, you should at least give a notice. So we set aside, give you liberty to issue them notice if you are so advised. Okay. Yes, Mr. Kaushik, you want to say something? Third, Mr. A. Rashid, Learned Counsel for the petitioner, also had Mr. U. Sharma, Learned Counsel for the Secondary Education Department of the Government of Assam. The petitioners herein, who was serving as subject teachers, assistant teachers in their respective secondary schools, and were appointed prior to what?
Before 2012.
Yes.
No, come to paragraph 3. What is the date? Paragraph 3. Did you read it?
Sorry, actually it is 37. Yes, 37. 12. It is wrong name. So that's
Okay.
37
Tell us the date at least.
extend 7 and
Find out the date where prior to
37 12
had had acquired their BA degree either from Guwahati University, a BA degree full stop. Upon acquiring the BA degree, the petitioners were granted one advance increment as per the order dated
order developed page 51.
Page 51 is not the date. Give us only the date.
No. This is the order in the
25/06/2021.
page 45. No?
Diba?
No, it is other order.
Page 52. In pursuance of DSC, DSC Assam
At
letter
least
number.
give us the date of the order. We don't need anything more than that.
This is the order by which we were like.
What is the date of that order?
Date of that order 25/6/21.
25/6/2021. But by the order impugned dated 6/10/2021 of the in charge inspector of schools BDC Borpeta, the one advance increment given to the petitioners were cancelled until further orders. Being aggrieved, this petition is instituted. By our earlier order dated 13/9/2023, we required the respondents in the secondary education department to inform the court as to whether any notice was issued to the petitioner by giving them an opportunity hearing prior to the order of cancellation of the one advance increment. Mr. U. Sharma, Land Counsel for the Secondary Education Department, upon obtaining information from the department, has informed the court that no such notice was given. Admittedly, by the order dated Akor 2000, dia order given 6/2/2021 niki. Itu 610. Ago 25 days. Admittedly, upon the respondents petitioners being given the benefit of one advance increment, a legal right had accrued to them for enjoying the benefit of the one advance increment. If the respondents are of the view that the one advance increment was incorrectly given, the option open would be to at least give a notice to the petitioner along with a hearing before any order of cancellation of the legal right pertaining to the one advance increment is cancelled. As no notice had been given, we have the view that the impugned order of 6/10/2021 is vitiated on the principle of vitiated or being issued in violation of the principles of natural justice. Accordingly, the order dated 6/10/2021 cancelling the one advance increment meted to the petitioner is set aside. However, if so advised, the respondents may proceed against the petitioner by serving a notice and giving an opportunity hearing. If the respondents are reviewed that the one advance increment was given to the petitioners when they were not entitled for the same under the law. Petition allowed as indicated. The order of the petitioner, Hemchandra Mishra, who was the Hindi teacher in Kayakai Higher Secondary School, died in harness on 21/11/2014, and on his death, the petitioner submitted an application for compassionate appointment on 8/12/2014, the said application was placed before the DLC of which district, which page? DLC,
DLC. DLC.
page number and date.
19. Base 45, 45. 45, my lord.
DLC of which date? Was there a DLC of Nalbari district in its
Nalbari
meeting of 21/3/2018, and there is a recommendation in favor of the petitioner. Serial number, page 45.
111.
Hmm?
Serial number 1.
Page 45, there is no serial number 1.
46.
Yeah, maybe you are confused with the page numbers and dates.
My lord, I'm
We'll
sorry.
take
my
up
lord,
after
it-
some time. You
Yes,
just
yes.
take note of.
42.
Can you take up after some time, Mr. Nair appears?
Lord, I don't have that rules, personal promotion rules. So,
Sorry.
Lord, the rules, my lord, relevant rules, personal promotion scheme rules, Guwahati University. I don't have that rules.
I have forgotten. Let me take up the matter.
Yes.
43.
Well, here the notices were issued. Matter relates to
Today, what
the
can you do?
rosters were not.
Understand? Today, what can we do?
Offline instruction, 5 offline instruction, and
43.
Well, this was the university matter where the rosters in terms of the Supreme Court's order was not complied. They went on de-reservation. Lordship had passed a.
That
Yes.
12/9/2023.
record.
To examine the given the respondents to produce before the court the roster maintained by them subject-wise where the recruitments are initiated. Mr. KL, this will require a hearing. Are you ready today?
Yes, sir.
Completely ready.
Yesterday, Rexall came and he given some.
So we'll just examine whether the.
Lordship, the contention of my understanding is that.
Why don't you do one thing? File a short affidavit, whatever you have to say.
Otherwise, Lordship, we are very in urgency to fill up the.
No, we'll take it up. Today is Wednesday. Right?
Unless an affidavit is on record, I won't be able to.
Next Tuesday की है सब खाली है
Tuesday की बात है।
Next Tuesday para जाने नहीं Sorry. Next Tuesday file your affidavit. We'll pass the final order.
Otherwise, Lordship, nothing has been, no post has been registered.
Understand? Therefore,
Well, we need to file a reply.
you do one thing. Today is Wednesday. File your affidavit as you have received your instruction. File it before Saturday with a copy. You also file your reply in the meantime.
But then let it be.
And on Tuesday we'll hear it.
I'm sorry to say, Lordship, earlier there were 4 litigations with regard to reservation. Then the association along with the petitioner, they were present when everything was finalized. Now again, the petition has been filed.
No, Mr. KL, what we look is whether the procedure, because reservation is a very complicated
Yes,
issue.
Lordship.
It's almost on the verge of being difficult to decide itself.
Yes.
So what we intend to do, earlier whatever may have happened, let it happen. Here, whether the appropriate procedure was followed or it was not followed.
Yes, Lordship, that is.
We'll hear Mr. Das, we'll hear Mr. K.
Yes.
We'll take a call. First, we'll find out what is the procedure.
Yes,
Second, we'll find out from the record what has been done.
Yes.
If you find it is as per procedure, petition will be closed. If you find it is not as per procedure, we'll give some direction how to do it.
Yes, Lordship, we
That's
have
all.
not the.
And we'll not interfere with any process. Instead of interfering, we'll ask you to redo it if it is
Comply with the mandate of the law.
contrary to the procedure.
Yes.
And if it is as per procedure, we'll close the petition.
We have meticulously followed everything.
Well, in the reply will be coming.
Understand?
And Lordship, by this way,
So, Mr. S.C. Kyal and Counsel for the Response simultaneously stated that the instructions as required has been received. An affidavit be filed on or before is Saturday. Date to DDO. With copy of the same to the learned counsel for the petitioner, and the petitioner may file their response on or before.
Tuesday, Lordship will take it up on Thursday because Tuesday date may be given. We'll file a reply.
No, we'll take it up on Tuesday.
Then he will have to give us on Friday.
No, if we give it on Saturday, work a little on Sunday.
He has some difficulties.
no, Lordship, before the Lordship.
Okay, you choose your date.
I'm asking only for a day because
Oh, you
I need
choose
to
your
verify
dates,
whether
okay.
the rosters were followed. And Monday is closed for that. Thursday, one day.
Monday is closed. Okay, Tuesday 3rd.
Okay, on.
On 3 and list on 5. In the affidavit, the respondents to clearly state as to what is the required procedure of law to incorporate the reservation vis-a-vis the rooster points with reference to the judgment of the Honorable Supreme Court in R.K. Savarwal and others versus State of Punjab and others reported in 1995 to SCC 745. And thereupon indicate that the required procedure of following the roster point reservation had been followed.
Here, Lordship, please to mention the instruction of the central government also.
The petitioners may also take any other stand as may be advised in the affidavit.
One thing, Lordship.
But this question has to be answered.
Yes, Lordship. I have brought this question, and the second question related to a Supreme Court order is that de-reservation cannot be done, whether they have done it, because we showed
The
that
affidavit
posts
will
are
also
abolished.
state as to whether any de-reservation has
Has
been
been
done.
done on the post.
And if yes, related to which provision of law?
44. We have not done, Lordship.
Lordship, I'm appearing for respondent number 5.
Welcome. You're welcome to appear. Now to lead your respondent 5. Who is the respondent number 5?
University Grants Commission.
UGC. Do you have anything to say in this?
No, my lord. This is basically with the Assam University.
They will follow the notice and then the reservation policy as per 2019 census.
No, everything let it be stated in the affidavit. What is the procedure? What has been done?
The interim order passed the status quo.
Interim order to continue till the next day.
Obliged.
In item 44, Lordship, order has been complied with.
In view of the order passed, it's been complied.
Yes, complied.
Who appears for the petitioner?
Petitioner, no, I will not be able. So I think the Lordship may mark as a record.
None appears for the petitioner. Mr.
A. Chetty, Lordship.
A. Chetty
For
for the
respondent
respondent contempt number
1.
1 and Mr. B. Kaushik for
3.
3. This contempt petition is instituted alleging willful and deliberate violation of the order dated.
The date is Lordship page
2016.
Yes.
16. Which order is violated?
Page 11.
Page 11.
1611 2018 and the relevant paragraph is page 18.
1611
2018 page 11.
2018
Is the last part.
in WPC. (4689) 2016 and other related writ petitions, wherein there was a direction issued
It is on
to
page
the
17. Page 17.
to the authorities in the education department as well as the pension department for doing the needful as regards some pension,
It is from the
as regards payment of pension to the petitioner to the writ petitioner.
Number.
Will be deliberate violation of the order detailed given, where is the direction? In course of the hearing, Mr. A. Chetri, learned counsel for the pension department.
For respond number 1. No,
Who is he? For the pension department has produced pension payment order in favor of the writ petitioner, contempt petitioner Baneswar Bhattacharya, sanctioning an amount of rupees 7130 per month,
And this year the amount
with
is
effect from 1/3/2007 up to 31/3/2016, and thereafter 16120 per month from 1/4/2016 onwards. In view of the pension payment order being produced before the court, we are of the view that there is no willful and deliberate violation of the aforesaid order of the court. Accordingly, we have noticed that the learned counsel for the petitioner is absent, but contempt is a matter between the court and the contender. And in a situation where a due compliance order has been satisfactorily produced before the court, we are of the view that there is no further justification to keep the contempt petition further pending merely because of the absence of the learned counsel petitioner. Contempt petition accordingly closed. However, liberty granted to the petitioner to assail the PPO referred in the communication dated 19/7/2003, if so advised by the
public.
Liberty granted to the petition to if so advised. The copy of the communication in 1978 kept on record.
45.
None appears for the petitioner on call. Although Mr. When the matter was called on 14/8/2020, none appear favor. Today again, when the matter is called, none appears. Contempt petition closed. Mr. Atmajindar appears for the responding contempt.
46.
Please, Lordship. Lordship, on 11/9/2023, we have taken fresh steps upon respondent number 7, Lordship.
Respondent number 7. Office note of 13/9/2023 shows that notice upon respondent number 7 had been issued on 13/9/2023. Await service report.
Lordship, interim order to be continued, Lordship.
Interim order continued till
May I
then.
prefer a short date because there is no.
This may be accepted in this case. Because the matter relating to anything committed to school.
And there's no.
You are appearing.
Actually, I am personally, my name is.
Sorry.
Because I was selected the president of the school.
Respondent number 7, Lordship.
Who is the respondent number 7? You are respondent number 7. From where you have become a respondent in a writ
See
petition.
what happened, the school management committee was constituted.
Achha. So how you are?
Because I have been, my name was selected.
What is a LOG school?
LOG school. There is a stay, and the school is suffering, there is no water, no electricity.
The earlier managing committee has expired and now there is no school managing committee to manage it.
But it is noticed that the respondent number 6 is Mr. S.C.K.L. Learned Counsel. 7 is Mr. S.C.K.L. Learned Counsel himself, and Mr. K.L. has appeared before the court saying that notice can be deemed to have been accepted. Accordingly, notice on number 7 is accepted. What is the communication dated 27/2022? Page number?
Lordship. Page 48, Lordship.
Page 14.
48.
14 is a part of the writ petition. Where is that order?
Lordship,
Where is the order dated 27/2022?
Is 47.
Page 47.
47.
That is the communication of the inspector of school to the principal.
Regarding
For-
what? That's what we want to see.
For convening a meeting of the school managing committee with the new reconstitution of it.
I am pleased to furnish the following. Yes, Mr. KL is the president.
Yes.
What is wrong with Mr. KL being the president? And in what manner it is illegal to warrant a stay order? Who is the petitioner? Devanand Singh. Who is it? And what is the locus standi of the petitioner to challenge Mr. KL being appointed as the president?
Lordship. I think after some time, Lordship.
After some time. But Mr. KL, if you are appearing in person, you cannot wear the robe.
No, Lordship, I'm not.
You are not appearing, then it's okay. You cannot be the counsel of the respondent.
No, I'm not appearing because I have no personal interest.
No, but you are made the president.
No, that is there. But for the
You have nothing to say.
I'm
If there's somebody makes, I'll do it the work. If they doesn't make, you are happy.
After some time.
At least tell us the legal ground why you challenge that, or you want after some time.
I'm not the welfare of the school.
Sorry.
Nothing more, nothing less.
Definitely. No, normally once a managing committee is constituted by the inspector, it should be honored unless there is some grave illegality in that.
That too, my lord, that has been approved by the guardian minister as per the 2021.
So therefore, we want to know what is the reason why we have challenged it.
47.
On last occasion, the matter came before the Loajima court and the notice to the respondent number 7 is returned due to insufficient of address.
Want to take fresh steps?
Yes.
Petition allowed to take fresh steps by rates of post alleged by dusty method upon the respondent.
I have already taken step on the next day.
Sorry?
I took the step. Already I have to.
No, you want to take steps or you have already taken?
Already.
But it had returned back.
No, after 20, the matter came before the Loajima court, and after coming to know that the notice was returned back, I have.
So therefore, you take fresh steps.
Yes.
48.
Our Devi was submitted due to some inadvertence. She could not take steps for service of notice.
Yes,
Have you taken steps?
Yes, Lord.
MS R. Devi, Land Council for Petition, states that in the meantime, after the order of 7/8/2023, the steps upon the respondent had been taken. The registry to verify and proceed accordingly.
49.
Respondent 2 and 3 has been taken, whether one might have recently transferred. So new incumbent, we have just served the notice on 4/9/23.
Mr. Sinha, what is the law of contempt? If he is transferred, is he absolved of the contempt?
No, that is again new
Then you want
incumbent.
to add somebody. Mr. B. Sinha, like proceeds for an adjournment to examine that the responding contempt number 2(1) had in the meantime been replaced by another incumbent.
Yes, obliged.
50.
50.
Happy to Lordship. Lordship, the order which is not complied, Lordship, is at page number 33, Lordship.
Page 33.
33. Relevant para is at 35, Lordship. Last para.
Have you communicated?
Lordship,
Where is the communication?
no, Lordship, earlier it was communicated as per.
No.
as per
If
the
you are
order.
filing a contempt, the order has to be communicated. Where is the communication? It is noticed that no material indicating the communication of the order dated 27/1/2023 is available on record for initiating a contempt notice. For issuing contempt notice, contempt petition closed, petitioner given liberty to approach again with appropriate communication. In view of the law that in the absence of communication, no contempt is maintainable.
51.
51.
May I please, my lord? My lord, with regard to that pharmacy college, wherein, my lord, that laboratory was to be extended, we extended it.
That's okay, but what is the contempt?
Contempt, my lord,
Which
because
is
but
the
that
direction?
consequential order was to be passed within.
No,
7
which
days.
is the direction?
Lordship would have it at page 37.
37.
Para 6.
37, para 6.
In view of the above, the authorities in the so and so. Necessary
Have you
modification.
approached?
I have approached.
Where
And
is
then,
the,
my lord,
where
may I
is the approach?
My lord, we had completed the work.
No. Petitioner to approach the commissioner.
No, my lord, we have asked for them, but by that time the work was complete, my lord. Then we submitted that papers. We submitted those papers before them with videographs saying that we have completed the deficiency in the enquiry report. Enquiry report is at page 29, my lord.
Then you file a writ petition.
Because, my lord, because we have done it on 14th. Lordship.
In contempt, first there must be a direction. Second, there must
there is a direction, my lord. Second,
understand. Second, there must be willful and deliberate violation.
Lordship.
Third, the order must be communicated.
No, we have communicated, my lord. We have communicated on 8/9.
Difficulty is, order is petitioner to approach the commissioner.
We have approached.
Mere communicating is not good enough.
No, my lord. We have, when there on 8/9, we have communicated that. But we have communicated with the my lord will only have page 38.
You are a very experienced constable.
I understood what my lord is indicating, my lord. But my lord will.
But whatever is submissions are coming from you.
It's a writ petition.
It's a writ petition.
It's a,
and
but
writ
my lord
petition
will
we
only
can
have,
take care of your grievance.
Lordship, my lord will only have 38, my lord. For a second, my lord.
Okay, we'll issue notice 6 weeks.
I'll come with a writ petition, my lord. But I want a notice here because my lord.
No, sorry. No, this a sword hanging on top of the head.
No, my lord will only have page.
If you don't follow me, I'm going to.
No, my lord will have page 38 for a second, my lord. My satisfaction, my lord. Why we have communicated, my lord. That's what I just wanted to show. But the fact is, the work was complete on that day.
Very well.
My lord will have that, my lord.
Mr. Nair, you file a writ petition, immediately you'll get the order. That the work is completed, responsible, look into it.
I'll have it by Friday before your lordship.
But why are you troubling yourself with a contempt petition?
Because, my lord, the problem was they are discriminating against us in spite of a clear direction from your lordship and the other 4 institutes who don't even have a house, my lord. They are being permitted, whereas, my lord, this institution.
Who are the responding defendant?
The health department, my lord. We have everything, 2 inspections done. But still,
Mr. Nair seeks for an adjournment in the contempt petition.
Lordship, that will be wonderful. I understood. My lord. I'll come back on Friday.
42.
Latest by Monday.
52.
May I please your lordship? Contempt petition, number 13, relevant number.
Page number?
13, third and fourth para. And as per the service book, my lord, person is going to be written.
What is this?
My lord, service book, person is going to be returned on 2nd December
Why are
2023.
you
my lord.
producing the service book? Where is the direction, Madam Das?
My lord, page
Which
number-
is the direction of the court?
Page number 13, my lord.
It's a direction to look into the grievance and take necessary steps under. Secondary education who appears? Mr. Kaushik, this is a very innocuous order. Direction to look into the grievance under Rule 14. Possibly Rule 14 is regarding seniority, I think. Based on seniority, possibly the person will or will not be a headmaster. There is also a representation.
Rule 14 requires its recruitment, promotion to the post of headmaster.
So man will retire on?
2nd December 2023, my lord.
So
Only 1 month.
his grandchildren will be happy if they find his grandfather to be a headmaster than a teacher.
I'll take his copy.
Take care. If he's entitled, give it. At least the man will go out of your service in a very happy mood. If he's not entitled, reject it.
I'll take it.
The Mr. B. Kaushik, Secretary Secretary, takes notice to provide the information, takes notice of the requirement, not notice of contempt.
Yes, sir.
Requirement to provide the information as to what further order the Director of Secondary Education may have passed pursuant to the order dated 36/2023 in WBC 3893/2023. List on next week.
Oblige me.
এখন দি দিব সেই মোৰ
53.
service book. Take your service book.
That is a lordship.
Yes.
My lord,
53.
complaints
Which order is violated, Mr. Deka?
My lord, order is the page 9, my lord,
Page
and
9.
operative person page 10.
Communicated.
Yes, my lord, page 11.
Notice 6 weeks, steps 3 days, raised to post.
Oblige.
55, 56.
My lord, it's with regard to a person who was a professor in Gerard Engineering College.
I'm seeking an adjournment, my lord.
Sorry?
Seeking an adjournment, my lord.
Mr. Kostab Gogoi has some problem today, my lord, he told me.
Any,
The only thing,
Adjourn on the inconvenience of Mr. K. Gogoi, Land Council for the
respondents, my lord.
no, which department?
Higher education.
For the
If your lordship can have
for
it
the
next
higher
week, my
education,
lord,
to be
because
listed again on
next week, my lord, whenever it's convenient to your lordship.
Mr. Boro is your savior.
60. Fine. Otherwise, the man
You
is
are
on-
also there in this matter.
She is with me, my lord.
59.
My lord, the lordship kindly see the impugn order.
Page number?
Impugn order is page 17. My lord.
Page 17. On the basis of seniority, list of BU Agamani is dated the day. What is wrong with this order?
Before that, my lord, page 16 is lordship.
Page 16.
I am the senior most teacher of that particular school. But suddenly, my lord, the district limited education officer, on the basis of the report submitted by the BU,
Heard Mr. J. Amil, Land Council for petitioner, also had Mr. B. Kaushik, Land Council for the Elementary Education Department. Notice 6 weeks, extra copies 3 days. Steps on respondents number. Six and 7 by registered post 3 days. By the order of the Block Elementary Education Officer Agamani dated 22/8/2023, the petitioner Manjula Sharma was allowed to be the in charge head teacher come member secretary of 41 number Kamarhat JB School by providing that the writ petitioner is the senior most assistant teacher of the school. But however, by the order impugned dated 14/9/2023 of the District Elementary Education Officer, the respondent number 7, Srimati Anjali Roy, had been allowed to be the in-charge headmaster, again by describing her to be the senior most assistant teacher of the school. In view of the conflicting provisions in the two orders, the order impugned dated 14/9/2023 shall remain stayed until further orders. Further consideration of the interim order would be made upon appearance of the respondent number 7 and upon production of the records by the respondent authorities regarding as to who between the petitioner and the respondent number 7 would be seniors in the school.
hello,
60.
Just after 6.
Please, Your Lordship. By this writ
What is
petition,
this?
the
petitioner has challenged the admission of MBBS as the respondent number 6 and 7.
As
Respondent number 6, 7, and 7 MBBS course.
MBBS, how much time is left now? Today is
27 years.
27. How do you expect us to decide it before 30?
It is a case here, it relates to the caste certificate.
Understand, but how do you expect us to determine the matter before 30 now? What prevented you from coming to the court earlier?
No, your
This was out on 14/8/2023, August.
No, in this case, second round they took admission in the MBBS motor community special quota, respondent 6 and 7. And there is some caste certificate, there is relating to caste.
But now, what relief can we grant you?
Because the respondent number 8.
No. Suppose we give the onus to Mr. Islam to pass the order. What order will you pass? You dictate.
Their admission.
See, if you as a council cannot think of an order, what order will the court think to pass in your favor?
Correct.
At the best, we can issue notice. But everything will be infectious because 30 is the last day. Yes, Mr. Gogoi, what is this matter?
Without the certificate, we cannot.
No, petitioner, what is the claim of the petitioner here?
Petitioners claim that they belongs to Motok community.
Achha, 6 and 7 do not belong to the Motok community.
6 and 7, though they belong to Motok community, therefore, inevitably they are not due to take in the higher mark. They are not claim the seat of especially for Motok community. And they
I not understand what you are saying.
Your Lordship, can you please
setting aside the admission of 6, 7, and 8 under the seat reserved for Motok. Why?
There is special quota.
Why should we set aside?
Case 15 candidate. 15 is the seats Your Lordship reserved.
What is case
category of seats?
Sorry.
8
Case
seats.
15, yes.
8 seats is especially reserved for Motok community, Your Lordship.
Huh?
OBC, Your Lordship.
OBC Motok is having 8 seats. Very well. Then
Your Lordship, Your Lordship. Now, Your Lordship, kindly say the notification, Your Lordship, of notification, Your Lordship, page
number
36.
36.
Noted to 2nd November 2021. In the interest of public service and in supervision of earlier instruction in this regard, the government will accept please to authorize the President General Secretary of Motok Hamilon to also.
So this is there. So now the Motok Hamilon will issue it.
Issue certificate.
So now
the respondent number 9 certificate is not belongs to Motok community. They have not. She has
respondent
not,
9. No, we are considering only 6, 7, and 8.
Oh, 6, 7, and
9.
6, 7, and 8. 8 years. 8 is not belongs to Motok community, and 6 and 7, though they have taken. They belongs to Motok community. They have shown affidavit. Your Lordship, and page 27. Page 27. Your Lordship, and
they are already admitted.
Admit is something
Well,
different. Your
as far as the
Lordship.
respondent 6 and 7 is concerned, well,
The writ petitioner assails the admission of the respondents for 6, 7, and 8 on the ground that although they were admitted under the category of belonging to Motok community, for whom 8 seats are reserved under the category of OBC, the 3 candidates in fact do not belong to the Motok community. The respondents in the through the Director of Medical Education to instruct the respondent number 6, 7, and 8 to go and appear before the special committee tomorrow.
no, my lord. So for 6 and 7, my lord, they have submitted an affidavit that they will not take any admission under the Moran and Motok community. But despite that, but giving that undertaking, now they have taken admission. 8, my lord, according to the petitioner, doesn't belong.
No. If they have given an undertaking,
why they have given, my lord, that's not there. Page 28 is
the respondents in the Director of Medical Education Assam to provide the information to the court as to why the respondents for 6, 7 were given admission under the category of belonging to the Motok community, for whom 8 seats are reserved under the OBC category. Although the said respondents had given an undertaking before the authorities that they will not seek any admission to the MBBS first year course under the reserved category of Motok community. As regards the respondent number 8, the petitioner asserts that the said respondents in fact do not belong to the Motok community. You should have filed 2 writ petitions. You cannot jumble up causes of action in this manner. Only thing, your client will suffer because time is very less, so we are entertaining. Otherwise, we would have dismissed this petition. The Director of Medical Education Assam shall instruct the respondent number 8 to appear before the what committee?
Committee, my lord, social justice and empowerment.
No, how do you describe it? Committee to say state
level scrutiny committee, task scrutiny committee.
State level caste scrutiny committee on tomorrow along, and the petitioner respondent number 8 to appear along with all relevant testimonials and materials to substantiate that she belongs to the Motok community. And upon giving the respondent 8 a hearing, the committee shall submit a report, shall make a report available before the court. Mr. R.M. Das. Your name, please. Mr. C. Sharma, appearing on behalf of Mr. R.M. Das, standing counsel for the Social Justice Department, takes notice of the order and accordingly instruct the committee to look. What else to do?
Yes. Otherwise, my lord,
At least
we have
tomorrow.
hardly 3 days, my lord.
That's a different. A copy. Give copy. Give copy to everybody.
Today.
See, we are going out of the way to help you, but don't come at this late hour.
And my lord,
You are creating pressure on everybody for nothing.
6 and 7, my lord, regarding 6 and 7.
That the DME will stay. Why, in spite of the undertaking, admission is given. And the Director of Medical Education after it to divo 6 and 7 or lagai to boy to line 8 or to belake dilu to 6. The Director of Medical Education shall also look into the aspect as to whether the said respondents are entitled to a seat under the Motok community, as the category Motok community, and in its wisdom may pass any order as may be deemed appropriate under the law. But in doing so, the response 6 and 7 should also be given hearing on the matter. List tomorrow will take up Kali division bench. Thursday division bench Kali. We'll sit at 4 o'clock for this matter. Single. On single bench copy of the order. Then you will have time for the next whole day also. But 4 will assemble for this bench.
#61.
Yes, Mr. Bhuya. We'll see.
My lord,
Medical.
matter relates to my lord, that the
Assam University. Nowadays, Assam University is very common respondent before us. Yes,
My
what
lord,
happened?
actually, what has happened? This another writ petition was moved before my lordship, my lord, and there is a direction to produce the result sheet, my lord. And my lord, from perusal of the result sheets, my lord, it appears that we have been selected, my lord, as per the note of that result sheet. I have annexed it.
What to do now? Issue notice or what?
My lord, in the meantime, provisional admission we may be allowed to take, my lord.
No, that we'll have to decide first, only then.
My lord, if the course goes on, my lord.
Mr. A.R. Bhuya,
My lord, my lord.
provisional admission is based on a primary satisfaction of the court regarding the legal right. It cannot be just, I have filed a petition, pass an order for provisional.
No,
Can't be that.
Lord, if my lord, just for a moment, peruse page 59.
Page 59.
My lord.
What is there in page 59?
Page 59, my lord, is a note prepared by the head of the Department of Agricultural Engineering. The following is the detail.
Following is the details list of
selected candidates. My lord, not selection.
list of
typing
selection
mistake.
candidates for admission under the.
My lord. And only the present 2 petitioner, my lord, had been selected.
Yes, what do you say of page 59?
Lordship, On last occasion, I produced the order sheet with your lordship. On that basis, the earlier petition was disposed of. Now they have challenged. Lordship, may please to see page.
List along with WBC so and so.
That is in disposed of.
WBC also disposed of.
5626.
Lordship, may please on Thursday. On that matter, I'll in the meantime I'll
Not tomorrow.
produce the record. No,
Tomorrow.
no, on next Thursday.
Next Thursday. Okay. List on so and so. I think we'll have to refer to the records of that petition.
Okay. Admission is.
Okay. Mr. Bhuya, there is a difference between an interim stay order and the interim positive direction. Positive direction would have to be preceded by at least a preliminary hearing and a primary satisfaction on the legal right that is available.
I can.
Stay is easy. That's a negative order. Don't do that. Positive order will need a preliminary hearing.
Oblige.
62.
Compassionate.
My notice letter is to non-issuance of non-creamy layer certificate. The petitioner, my lord,
For medical admission.
for medical admission. Here we have challenged the order of the deputy commissioner at
Page
page
number?
26, my
Page
lord.
number 20.
Petitioner's prayer has been rejected, my lord.
Pursuant to the High Court order. Now, what is wrong with this
Now,
order?
my lord, your lordship may kindly see the recommendation of the NCBC, my lord, the National Commission for Backward Classes, my lord. As per the recommendation of the NCBC, my lord, the review has to be done after every 3 years, my lord, on the basis of income, on the basis of price level.
Very well.
and all that.
Today, a non-creamy may become creamy after 3 years,
My lord,
or a
it was-
creamy may
it
become
was
non-creamy
reviewed
also.
till 2017. After that, there was no review.
Who had not
Because-
done review?
My lord, the government of India, my lord, your lordship may kindly see at page 50, my lord.
Page?
Only the relevant page 49, my lord. Para 4, my lord. Pursuant to the aforesaid office
Madam
order.
Chaudhary, this is the order of 18-9.
Yes,
Had you
ma'am.
been in the court on 29,
2004, yes, ma'am.
we would have conferred with the government of India regarding the review.
Yes,
But
ma'am.
today, hardly 48 hours are left. What can we do?
My lord, time is.
Because this will require initially a direction to the government of India to conduct and review whether the non-creamy layer can be raised from rupees 8 lakhs to a higher figure.
Yes, my lord.
Once it is raised, then we'll have to examine whether your 11 lakhs will become creamy or non-creamy. But that cannot be done in 48 hours.
But regarding the, your lordship may kindly see, there is a, my lord,
And we can't put this extra pressure on the government of India that do it immediately. This will again require a lot of materials and decision that what should be the reviewed upper limit of a non-creamy layer. How can I compel them to do it within 1 day?
there is a clarification also at page 30, my lord. This is by the Undersecretary to the Doctor of India, my lord.
See, 30.
Page 30, my lord, there is the question, my 30. What is the scope of the expansion? Income from salaries or income from agricultural land shall not be clerk given to the income below income wealth test. The answer is, my lord, the next page, my lord, page 31, my lord, para 10, my lord. It is explained, my lord, in detail. My lord, the source of income, my lord, it must be salary as well as from other source, agriculture. Your lordship may kindly see at page para 10 at page 31.
So now how will it help you?
My lord, there is no time, that is why, my lord.
Sorry, and even if you take note of that 2004 OM, how will it help you?
My lord, that is there, my lord. You have to,
We understand your problem. We also understand that 2004 OM. But how will it help you today?
today, my lord,
Nothing.
it may be taken as a
Only way
special
out
case.
is requiring the government of India to review and reconsider what should be the upper limit.
Yes.
But we can't enforce it on within 24 hours.
And admission
Today
is
is
also, my lord,
27. Hmm. 27 নহয় জানো? 27. 30 is again Saturday. 28 and 29, 2 days time you have any order that will pass. Yes, Mr. Gugoi.
At present, Lordship, page 33 is.
You are appearing for
I am for the Lordship central government.
central government.
At present, Lordship,
Why the central government has not reviewed after 2017 in 6 years?
2017,
Although
Lordship,
Madam Chaudhary says it should be done every 3 years.
Lordship, there is a recommendation of the committee in 2015, Lordship.
No, in 17 it was raised from 6 lakhs to 8
Lordship,
lakhs.
after the recommendation, it was raised to Lordship up to 8 lakhs, Lordship.
But that was in 2017.
Lordship.
Madam Chaudhary submits that review should be done every 3 years. So from 17 to 23, it should have been done at least twice. And she feels, had you done it in appropriate time, with the 11 lakh income, her client would have been a non-creamy. Because of your lashes of not doing, she is missing out a medical bill.
That point
This is,
today-
I think, her case.
Yes, ma'am.
That point today I cannot reply. Otherwise, Lordship, as per the government policy, 2017 is told in the field, Lordship. 2017 says that, Lordship, it should be up to 8 lakhs, Lordship. And that was also done after recommendation of the
Madam
committee.
Chaudhary.
My lord, so far as the NCBC's recommendation is concerned,
Madam Chaudhary.
it is a constitutional body, my
Madam
lord.
Chaudhary,
Yes, my lord.
in medical jargon, there is a saying, operation successful, patient died. Your case will be that. Ultimately, legally he will succeed, but it won't be of any benefit to you.
Yes, my lord, challenged it earlier, my lord.
Possibly in 48 hours, we cannot compel them to do anything.
If it is done, it may be required in a for future.
Only thing order we can pass, we'll take it up tomorrow. In the meantime, have you reviewed and enhanced it? If it is already done, tell us. We'll direct the DC to consider as per the enhancement.
If Lordship
That's the
permit-
only thing we can help
Lordship,
you.
If Lordship permit, I can submit it, Lordship. The review was not done because earlier one case was also listed before the Honorable Court, Lordship.
Huh.
That query was also put by the Honorable Court, Lordship.
Why it is not done?
Lordship, that part they have not replied, Lordship. Presently, that is in the field, Lordship.
So now if our client seeks compensation, what will you do?
That part today I cannot say, Lordship. Otherwise, the policy decision of the government, Lordship, they says that.
Where is the provision should be done every 3 years?
My lord, this is the recommendation of
No,
the
no.
NCBC, which is
Oh.
a statutory body.
Madam Chaudhary, you made
yes,
your submission.
yes,
Review should be done every 3 years. Where is that
It
provision?
is there, my lord.
Page number?
At page, my lord, at page 49, my lord.
It's a recommendation. of the
Recommendation, it is binding, my lord, because it is a constitutional body, my lord.
49, where is it?
Your lordship may kindly see at the para 4, my lord. Para 4, but only taking into account the changes of price levels, consumer price index numbers known as cost of living, index numbers and other data recommended to raise the income limit for determining the creamy layer among the other backward classes from the existing rupees so and so, and to have a periodic review for every 3 years. And in the next page also, the same thing has been repeated at para 6, my lord.
It's a recommendation of the Lordship, the National Commission for Backward Classes, Lordship.
And this is
It's a
binding, my
recommendation,
lord.
Why are recommendations made?
Lordship.
Why are
On the basis of that recommendation made in 2015.
Mr. Gugoi, why are recommendations made? To be
Recommendation,
ignored or to be followed?
Lordship, they have recommended to follow, Lordship. After that, government has to decide, Lordship.
Now you have to answer.
Lordship, after that 2015 recommendation, Lordship, 2017 OM is come, Lordship. 17 OM is come, it enhanced to 8 lakhs, Lordship.
Up to 17, it has been followed. Thereafter, my lord, no review.
15
has been done.
recommendation, it was, Lordship, enhanced to 8. 17, it was implemented, it was enhanced to 8 lakhs, Lordship.
History we are aware.
Lordship.
We are only present.
Present, Lordship, present, whether there is any
Why it
other.
is not done?
Lordship.
Why it is not done? When the law requires it to be done, then why it is not done?
It's a recommendation of the committee. That recommendation was already, Lordship, followed by the in 17, Lordship. And
Mr.
other part, Lordship, today.
Mr. Gugoi, you are evading the actual question.
Lordship.
If the requirement, there is a requirement to review every 3 years, why was it not done for the last 6 years?
Lordship, that part today I cannot say. Otherwise, Lordship,
You will take up after some time. You just
Lordship,
call up these authorities, ask them why they have not done.
it's not a Lordship statutory provision that Lordship it should be that.
Are you to understand that anything not statutory, not required to be followed?
Lordship, that part
Your government will be in trouble.
I'm not saying that.
If you observe that anything that is not statutory is not required to be followed,
that part I'm my submission is not that, Lordship. But otherwise, Lordship,
you inform us. We'll take up after.
Lordship, I will try, Lordship, whether I get back or not. Lordship.
No, call up that man. Ask him why it is not done.
That particular persons today, just not tomorrow I can. Lordship, I can try. Today I cannot say that, Lordship, I will with the person or not.
Tomorrow. For the information as to why the authorities had not reviewed the upper layer of the non-creamy layer for OBC, although as per page 49 of the writ petition, there is a requirement of a review every 3 years. It is taken note of that the last determination was as per the, where is that 17 one?
17.
As per,
Where
is the order of the deputy commissioner?
Page 33. Order of the deputy commissioner 26, my lord.
26. Although the last review, where the last review was made by the letter dated 13/9/2017. List tomorrow for the necessary information as indicated. In other words, can we do something for the petitioner? We want that.
If possible, petitioner give a soft copy of the petition, then I can today onwards I can communicate it, Lord.
Give both hard and soft.
Hard copy, I know, only soft copy, Lord.
Soft copy.
Soft copy. I require.
You have a soft copy. Annexures also.
Yes, ma'am.
Then give it.
How many did you want?
63 for orders.
Correction, ma'am, please.
Heard MSK Devi, Land Council for the applicant. Also heard
Correction.
Mr. B. Kaushik, Land Council for the Secondary Education Department, and Mr. P. Saikia for the Deputy Commissioner Nalbari. By this interlocutory application, a correction is sought for in the order dated 29/2023 in WPC 3387/2023. Where is the correction now?
My lord, 2 line and 3 line of the certified copy of the order, it is shown as Elementary Education Department, but it should be corrected read as Secondary Education Department.
Where is that line?
Second paragraph. Order, Lordship, can we see the order? Peruse the order.
No, we are perusing.
Elementary,
Where is that
first line, my
expression?
lord. Elementary education, it should be secondary
Where?
education.
Which line, madam?
First line, madam.
First line of the order.
Also heard SMT system.
Also SST, SMC 60. Learned Council.
A correction is sought for in the first paragraph of the state order where Mr. SMT Chisti Land Council had been described to be the council for the Elementary Education Department, and it is stated that the
It should be
correct
secondary
correction
education.
not to have been
Secondary.
Mr.
Secondary
SMT Chisti Land Council for the Secondary Education Department. For the
And
stands
my
corrected
lord-
as indicated above.
Yeah, there is another.
One more
also.
correction. Where is
Yeah, my lord, the additional senior government advocate for the deputy commissioner Hailakandi, it should be Nalbari.
Recently, you have been to some place. Very recently, did you visit some place? Very recently, did you visit some place?
Yeah, he was- No, I'm not
going.
which required a change of the diction you are using.
Sorry, my lord. I'm extremely sorry. Planet Council Senior Government
No, I
Advocate for
think
the Deputy
you-
Commissioner, Nalbari.
Instead of yes, you use some different expression,
Yes.
which is used more popularly in another country. Yes, now which word?
It should be Halakandi, it should be Nalbari, my lord. Again,
Further in paragraph 4, the order should be read to be DLC of the Nalbari district and not Hailakandi district.
again, my lord, again, it is.
Both corrections.
The father of the petitioner read Ranjan Shuklabaidya, who was serving as a assistant teacher. Lordship kindly peruse the petition, madam. Then your
Will
lordship.
not produce. What correction do you want you to tell?
It should be father of the petitioner late Chiddeswar Burman. Rajbangshi was working as a gate 4 employee. It should be in Milan High School.
And further in paragraph 2, the deceased father of the petitioner should be read to be serving as grade 4 in 182 Choto Jamira Lower Primary School and not assistant teacher. All corrections as indicated above allowed.
64.
To cut this smart take over huh?
May I please, your lordship? May I please, your lordship? The matter pertains to the regulation of the service of the petitioner in a
Today,
higher
what is to be
secondary
done?
school.
Affidavit. You want to file affidavit?
No, it is
Yet received instruction.
Mr. B. Kaushik for the Secondary Education Department, prays for 4 weeks time to file a praise on this of 4 weeks.
65.
Service is complete in case of all the respondents. Yes.
Want to file affidavit? Mr. A. Tobilder for the hiring praise for 4 weeks time to file affidavit. Pray allow this after 4 weeks.
Item 66 also same order.
Same.
Alright.
67 for hearing.
Relating to the appointment of.
Are you hearing the matter today?
My lord?
Are you hearing the matter today?
As
Yes.
your lordship, as
Are you
your-
ready? Completely ready?
My lord,
No,
matter is-
you take your call. If you're ready, we'll hear you.
Actually, one issue.
No, we understand that. Are you ready? If you're ready, we'll hear you. Mr. Das, are you ready? Don't take adjournment after the hearing has started. Take your call right now. If you're not ready, tell us, we'll fix a date. If you're ready, we'll begin the hearing.
Next week, my lord.
But no adjournment once the hearing starts.
Next week.
Actually, my instance matter is listed, lordship. I have mentioned the matter. Let lordship fix a date because college is suffering, lordship.
Definitely.
The one post is vacant.
But we don't want to waste a judicial time.
Exactly,
in
lordship.
this
Next week, any date, lordship, only fix a date.
All the learned counsel for the parties agrees that the matter can be heard on the next returnable date, and as agreed, list on, take a date whenever you are ready.
Thursday.
5:10.
No, date, whatever they choose. You choose your date, but on that day we'll hear you.
Time being 39.
Yes,
Timing 39.
Mr. Kev was not there. Huh?
In this case, the petitioner requested for NOC for joining in some other institution. In the meantime, what happened when she was working as a head of department, some central fund was allocated to the department. That were misappropriated by forging the documents. Thereafter, the central government instituted the inquiry through CBI
Against the petitioner.
against the petitioner. That's why we have refused to issue NOC to her.
File an affidavit. File an affidavit.
I'll file affidavit.
Mr. S.C.K.L. and counsel for the respondent summary prays for 2 weeks time. 2 weeks time to file the affidavit, and it is stated that the instruction has been received and the NOC to the petitioner could not be issued in as much as there is an allegation of misappropriation of certain fund, and for which an inquiry had already been initiated.
By the central government.
An inquiry by the central government has already been initiated.
behind the back, my.
Whatever it is. List after 2 weeks. List after 2 weeks.
Lordship, may I pray my lord a date, my lord?
Date. Did you?
Item 40.
Apply.
Lordship, we are appointed as a SC officer in 1999. We have GPF
Adjourn on
account.
the prayer of Mr. Chaudhary for the consideration for the respondents. Yes.
Lordship, I pray for some more time, Lordship.
Mr. B. Chaudhary, line counsel for the respondent BTC prays for 4 weeks time to file the affidavit. Prayer of date after 4 weeks. It's 2023 matters. Slowly we have to come down. Initially 4 weeks, 3 weeks, 2 weeks. Then put the actual question.
41.
In this case, I have not annexed the district level committee, but I have mentioned in body, my lord, that is para 10, page
But that remains a statement.
statement I made.
How can he pass an order based on
Yes, my
statement?
lord, I have to file.
The
a
petitioners prays for an adjournment to produce the resolution of the district level
District level
concern,
committee.
district level committee.
next week, my lord.
Let's
Hello.
wait a minute.
42.
That is the next week date.
42. Here's Mr. Nair.
I'll pray for some time in
My
this
lord,
case.
the affidavit has been filed. My lord had considered the matter twice. Twice the matter was remanded back to them. The issue is very simple, my lord. I was a professor. I opted for a higher pay reader post, my lord, in 2002. Now, for that scheme, I'll have to qualify my residency as of March 31st in the previous year, that is in 2001. I was shortfall by 7 days. I applied before the VC.
Did we hear this?
My lord, twice, my lord. My lord, there are 2 orders, my lord, remanding. Still they are sticking to them. The VC
Where is the earlier order and where is the rejection order?
The lordship would have
earlier
the
court order.
Earlier
Court
order
order?
was a little bit cryptic. So, my lord,
We'll remove the crypt.
my lord, that was
My lord
more-
would have page 64.
It was revolving around that footnote, my lord, that office note.
Page number 64.
4, my lord.
Yes.
This is the
Where is the
consideration, my lord, at page 67.
67.
Para 6, my lord. There was a committee's report. My lord wanted that to be taken note of. The rejection
to take note of the recommendation of the committee dated 21/3/2017,
which was constituted by the executive council.
Just a minute,
itself.
this instance is where is the 21/3/2017?
My lord has quoted that in detail in page 65 onwards, my lord. In my lord's order. The conclusion at page 66 onwards, my lord.
And what order the university?
My lord,
has
page
passed?
70. My lord would have the lower portion, resolution number so and so. Nothing was done.
Who are the members of the executive council?
My lord,
kindly turn to Annexure 12.
No, we'll
The
turn
next-
now.
next order.
No, we'll hear you later. Who are the members who have signed this one?
My lord, that my senior may know, my lord, but this is not disclosed. Thereafter, again, I challenge that.
Let it be.
Page 73, my lord. I challenge that.
Okay, again.
Again challenge, man. Then, my lord, in page 73, para 4, noted that you have not taken the committee's report into consideration. Then comes the impugn order.
Now what order is passed?
Page 75, my lord. My lord, they have written whatever can be written.
Very elaborately dealt with, my lord, along
And
with all the legal provisions, my lord.
I don't understand.
Who is the author of this resolution?
This is, my lord, by the executive council. itself.
Who is that?
The executive chairman is the vice chancellor. Vice chancellor is the chairman.
No, not the vice chancellor. Man next.
Would be the registrar.
The registrar of Guwahati University to remain personally present before the court on so and so. To explain.
May I submit?
Explain the. No, you submit on that day.
No, only
You submit on
my
that.
learned friends, my lord, entire matter based on only one thing.
Mr. P.J. Fukon.
Miller. That Puranjot Singh of Supreme Court's that judgment, as well as that.
Mr. Fukon, every judgment will be there.
Miller.
If those judgments are applicable and the executive council wants to take a view different from the court, the only remedy for you is to either file an appeal or a review. On your own, executive council of a university is not a supervising authority over a high court.
No, Miller,
Therefore, it is.
Miller,
You are doing it, Mr. Fukon.
Only 1 minute.
Mr. Fukon will not. We have passed our order.
Earlier, Miller.
You have passed our order.
Miller, dishonorable.
You'll be in trouble. I'm telling you.
No, Miller, may I only 1 minute? I will take only 1 minute.
But your 1 minute may cost you many minutes. I'm telling you.
Yes, Miller. Miller.
Your 1 minute may cost you many minutes.
Miller, that page 74, Miller.
See, we have some better work to do than all this going after this Guwahati University.
Miller, this
you have to leave aside your ego.
Miller, no, Miller, it is not. No,
you have to leave aside your ego, Mr. Fukon. Tell your university.
No, Miller, there is
your
no
university
ego problem,
is an
Miller.
authority where under entity under Article 12, where writ jurisdiction is applicable.
This honorable court has directed the executive council to take decision, Miller. To elaborate, Miller, that page 74,
No,
Miller.
you are again wrong.
Page 74.
You are
Miller.
again wrong. Court is very specific. Pass an order taking note of the recommendation of the committee.
All those aspects have been dealt with, Miller. That is why, Miller.
Where are you dealing? I'm telling you, your 1 minute may cost you many minutes.
Miller,
Yes, argue.
Miller, may I take your lordship? I'll
Page 75 we are reading.
74, Miller. Page
No,
74.
we'll read 75, not 74.
No, it's page 74.
Yes.
Miller, the dishonorable court's direction.
Yes, we understand our order. You read 75 now.
75, Miller. Miller, the main, it is typed copy, Miller. The main copy is Annexure 13, page 77, Miller. Meeting of the Executive Council. Extract of the confirmed proceedings of the fourth meeting regular of the Executive Council. Item number 8. Discuss the matter in light of the following note, which was placed in the meeting. The notification under so and so, dated so and so, invited application for the purpose of personal promotion
Very
of
well.
university research.
We have heard it.
Miller, and the last part, Miller. I'll be very brief, Miller. In view of the aforesaid context.
By the order dated, yes, we have read it. We don't need so much of time to read one page.
Miller, every aspect of that.
We have taken note of. We have taken note of. We'll also note your submission also. By the order dated 12/11/2021 in WPC 5924/2021, comma, the observation and recommendation made by the committee constituted by the Executive Council in its report dated 21/3/2017 was taken note of, and the recommendation of the committee in the said report is extracted as below, page 66. Accordingly, direction was passed on the agreement of the Learned Council for the Guwahati University, also on the agreement that the claim of the petitioner for promotion as reader from the year 2002 be again placed before the Executive Committee in order to enable the committee to take note of the recommendation of the committee dated 21/3/2017, meaning thereby the recommendation as extracted before. But the Executive Committee of the Guwahati University in its 7th meeting dated 27/12/2021 had referred to the order dated 12/1/2021 passed by the court, but provided as extracted 70. it appears that at that stage itself, it appeared that the Executive Council is deliberately, willfully and deliberately violating the order direction of the court. But however, a lenient view was, in the circumstance, the writ petitioner instituted WBC 2907/2022, wherein the order dated 2/6/2022 was passed, and
Paragraph 5
and
page 7. It has been remanded back.
please don't interfere. And again, the recommendation of the Executive Council in its 7th meeting dated last past 20, when a lenient view was taken, and it was understood that the Executive Council had that the order of the Executive Council appeared to be short of a reasoned order, and nothing was mentioned about the recommendation of the committee referred above. Accordingly, the matter was again remanded back to the Executive Council for a fresh consideration by complying with the requirements of the order dated, judgment dated 12/1/2021 in WC 5924/2021. That is, to pass a order by taking into consideration and doing the needful as per the recommendation of the committee dated so and so as referred above. Upon the matter being remanded back for the second time, the Executive Committee in its meeting dated 7/11/2022 had passed the following order. Page number 77. A reading of the order dated appears that the university, instead of following the recommendation of the committee dated so and so as directed by the court to be done twice in its orders dated Iman in WBC Iman and Iman in WBC Iman, had again sought to circumvent the entire order and give its reasons as to why the order of the court is, as to why the Executive Council finds that the direction of the court is not to be strictly complied with, and further resolve that their reasons be now presented and approved for necessary action and appraisal to the court, meaning thereby that the Executive Council is now trying to say that the court be informed as to why its judgments are wrong and why it cannot be implemented. The entire conduct appears to be a willful and deliberate violation of the court's order. Being satisfied, notice of contempt be issued to the Registrar Guwahati University.
Lord, may I submit one thing?
We have passed our order.
Lord, only that
We have passed our order, Mr.
recommendation have been noted.
We can still spare you if you go back and do the needful. Choice is yours.
Lord,
Otherwise, there is no other way to handle this kind of elements. And we don't need such kind of academicians in this work.
Milord, that was noted, Milord, that we will comply.
Noted.
Milord.
Yes.
That we will comply then, Milord.
You want to comply?
Milord, we will comply, Milord.
You will comply.
Milord.
You withdraw this one, comply, bring it to us. List next week. We are not passing any order. It will draft to 21.
I'll do.
We are not giving any observation. Do whatever you do.
Gotcha.
46.
Mr. Saikia, being an officer of the court, you also understand that certain things should not be done. And if this hierarchy is broken once, this country will collapse, I'm telling you.
Look,
Tomorrow, what will happen, you know? Your middle level officer will disobey your registrar and vice chancellor. Then your low level will start disobeying the middle level. Then your clerks will start disobeying the lower level. Then your peon will start disobeying your clerks. Ultimately, your peon will be the boss sitting over everything.
I completely agree with your lord.
So please don't do it. If you find anything incorrect in the judgments of the court, file appropriate application. We are ready to consider. And mind you, courts have no ego like the Guwahati University. We are ready to hear anything you want to submit. Please take note of it and instruct your officers accordingly.
I only, my lord, as a my lord court officer.
And it's a request, please don't do all these things. Don't try to be oversmart and overreach the court's order.
Oversmart and ego, my lord, that aspects, my lord, not
It is so. Otherwise, third time the same thing doesn't happen, Mr.
And that was noted only, my lord, not comply, my lord. That is why, my lord.
It may happen once, but not thrice.
46.
Most of it.
We are not observing anything. We are listening next week. See what action you take. If you don't take, we may take the matter as per law.
I'll submit on that.
Don't submit anything. If you want to take remedial measure, only that we are allowing you. We are not allowing you to submit anything. Submission, you'll do it in the contempt petition.
Only a clear direction that aspect, my lord, that will be, my lord, complied with by the university. Not
Direction is very clear. Recommendation should be, and if you are arguing, agor order to thakok.
No,
Yes.
no, my lord. I'm not pressing like that.
See, we also have our time, precious time, and there is a limit of the word called patience also.
Next week.
And don't play with it. Yes.
Next week.
List on so and so. Upon list on so and so. On the prayer of Mr. PG. Yes.
May I please
This is atrocious, Mr. Pupan. The respect an academic institution like university should have will be lowered by these acts. It will not be enhanced. Yes. Cancel. Come back. Submit. Submit. Yes. Please submit. It ordered for you.
I'm not clear, my lord. That is why, my lord. I'm extremely sorry.
Mr. Pukan, you have the habit of playing with fire. We know about you.
No, my lord.
Please continue. And playing with fire burns, mind you.
Now I'll also submit one. I'll
Yes.
also show one.
We'll complete hearing today itself.
I take your lordship first to the.
No, don't take us anything. Submit only. We have already read everything. We can't allow you time again and again for reading all these things.
You know, the only.
You make only your legal submission, please.
This honorable court, on the first two litigation, directed to the university authority to note the recommendation of the committee. The word is very important, note it. So Guwahati University will have to note the recommendations of the inquiry committee constituted by the university authority. So, my lord, the first litigation, then the second litigation.
And do you mean to say taking note means you are allowed to decide the matter in a different way? Taking note is to comply with it.
So we have taken note of.
Mr. Don't make these atrocious submissions, Mr. Pukan. Every reasonable person understands when the court asks to take note of something and do accordingly means whatever is provided there. Court never means that taking note is you will redecide the judgment of the High Court.
Taking note of
Yes,
the recommendations of the committee.
it is rather atrocious on the part of the Guwahati University.
I have not completed my submission.
Complete immediately. Yes.
I should recuse.
Please complete it.
I should recuse. My lord.
No, you
I
should
may
not
be
recuse. You please. We will not allow you.
Yeah.
We'll draw notice
Dignity
against
of
you
the
also
court.
then.
I may
Please
be
complete.
recused, my lord.
Because every time when we come to something, you say you're not complete. Please complete.
I may be recused.
No, sorry, we refuse that.
I won't say anything. my lord.
Sorry, no.
I may be
Please
recused, my
complete.
lord.
What you want to say, please tell us.
I may be recused.
Sorry, will not allow. Will not allow.
I won't say.
Sorry, will not allow. Will not allow you to recuse.
My
Because
only
we are
prayer, I
very
may be
polite with you for the last half an hour. We are doing everything possible for you. We explained you. We clarified to you. You again said, yes, we'll reconsider and come back. From there, you again started shouting that I am not being heard.
I'm not
That too from that
shouting.
corner, not even from the podium.
Your lordship has
You please
directed me,
argue.
my lord.
No.
That is why I have.
Mr. PJ Fukandi is directed to
I
argue
may
and complete his
I may be
argument.
recused, my lord.
No, then a contempt against you. It's a direction. You complete it.
Next week, my lord. I
No, today. Please, let us be clear what you are trying to say. Let us be clear.
My lord,
Yes,
since
sorry.
some unwarranted situation, my lord, has cropped up, my lord.
Anything may happen. Please complete it. And this is not the first time it's happening. Please argue. Argue. So word note is understood to be that you can redecide the judgment of the High Court. Very well. Now next submission.
My lord, I won't be able to.
No, we are bound to. You are bound to.
I may
After
be
wasting
recused.
half an hour, we cannot allow this behavior.
At
Please.
least today, I may be.
No, no,
recused,
today
my lord.
itself. We'll sit up to any time we want today. Please complete it. Today's court hour is unlimited until you complete.
My lord, I'm not ready. my
Sorry,
lord.
no,
My lord,
we cannot
I'm-
accept.
At this stage, I am not ready.
No, we
my lord.
cannot accept it, Mr. Phukan. Please bear with the court. You complete whatever you wanted to say. Thrice or four times you have said I am not allowed to complete. So we will allow you to complete.
It will take some time, my lord.
Let it take any time, any amount of time, let it take. Today there is no court hours limit, unlimited.
My lord, I am withdrawing from this case, my lord.
Will not allow you to.
I am
Will not allow.
recused, my lord. At
Will
least, my
not
lord,
allow
as
you
a
to
court
withdraw.
officer, my lord.
No, we
being a
refuse
court
that.
officer, my lord.
No,
I
we
may-
refuse that. Sorry. No.
I won't argue in this case.
No, we'll refuse it. I'm telling you, we are refusing it. In the circumstances that preceded, we'll refuse it.
At least, my lord, that may be accepted, my lord.
No,
I may
will
be
not-
recused,
will
my
not.
lord. Otherwise, my lord, I won't be able to, my lord, submit or argue.
No, no, you can do anything you feel like because you are ready to submit. Please continue with it, whatever you are ready.
At that time, I was ready to.
No,
submit,
now
but
it cannot
my
be.
lord,
This is another contempt.
after this
Sorry.
emotional outburst from this,
No outburst is there. We just asked you to continue. That's all. And in a stern and stricter way, we said, because of your behavior. That's all. There's no outburst. That is again another contemptuous word you are using. Please continue.
you know, as your lordship pleases, my lord, I don't have anything.
Sorry, no. You can take some time. We'll call up after some time. But today itself. Please sit here, steady yourself, say whatever you want to study till we take up the next matter.
May I go out for a little while?
Sorry,
May I go out for a little while?
but we'll take up.
My lord.
Go means you'll be brought back to the court. You'll have to come.
I'll definitely come.
Yes.
But I again pray before your lordship. I
We
may be
reject that.
recused.
We reject it. We have been very patient with this university. Not only, I remember even at the last hearing also, we are very patient. In the last writ petition also. Please. You complete your argument, we'll hear you to the full, to your maximum satisfaction. Yes, next item. Call it after some time. After 10 minutes, it will be called. Yes.
May I please?
Yes.
May I please, your lordship? In this case, lordship, 4 names are submitted before the authority for selection of president, vice president. First letter is page 37. IS asked the headmaster of the institution to submit 2 names, each for president and vice president. Page 37.
So today, what is to be done? Are you hearing this? repetition?
This is that matter for admission hearing.
No
Service is
admission.
completed.
No, pleadings are over. Have you filed your affidavit? What do you want to file?
I can produce the record, my lord. Your lordship wanted to know what was the ground for stalling the reconstitution of the school managing committee, page 47. And they
No.
they are challenging page 47, my lord, the communication 28 July 2022, appointing the president and the vice president of the LOZ school, my lord, school managing committee.
For that LOZ school?
Yes.
So now?
Lordship wanted to know from them. So what was the ground?
No, on what ground you have challenged this, Mr. Baruia?
Lordships, as per their instruction, IS instructed 2 names to be forwarded, each for president and each for vice president.
This is a provincialized school?
Provincialized. And accordingly, 2 each for president and vice president have been forwarded after holding meeting.
Who had forwarded?
Local authority and the school authority forwarded, lordship, after
School
holding a meeting.
authority forwarded 2 names.
School authority.
Okay.
Thereafter, the inspectors again asked 4 names to be forwarded, each for vice president and president. And accordingly, by holding meeting, 4 names have been selected and forwarded. For select. Subsequently, the respondent numbers 2 names have been selected. They have not been forwarded by the authority school by holding the
So is there any bar that they mandatorily they'll have to forward the name recommended by the school authority? Is there any such provision?
Yes, as per guidelines, lordships, page
number?
Page 25 is the notification, lordship, dated 27 June 2016.
Yes, what does it
And
provide?
relevant portion, page 28.
28.
Selection process of president and vice president of SMDC. Lordship, got it? Bottom.
See, inspector school after consultation with the principal.
Lordship.
Consultation doesn't mean that whosoever is recommended is binding on him. He will only take his views. And after taking the views, may accept it or may form another view.
And lordship, kindly see page 37 as per instruction of the inspector.
Page 37.
Page 37. Letter dated 30th of September 2020.
And I have the honor to request you to submit 2 names for very well.
Lordship. Then 2 names have been forwarded.
Very well, we understand. But what we are trying to ask you is it mandatory? The word consultation, does it mean that it is mandatory for the inspector to recommend only the 2 names given by the principal?
Not given by the principal. The local people, along with guardians, lordship, by holding a meeting, selected the 4 persons on the as per directions of the lordship, as per notification as well as the
These are the difficulties which we just now we had one bad sit with Mr. Pradhan. Nowadays, the councils are becoming only adamant and nothing else, and you are not ready to appreciate anything. We are asking you whether this recommendation, whether by local people or by guardian or by the principal who are required to be consulted, does the word consultation means it is mandatory for them to give only those 2 names? Or it is only consultation means only?
Here is the case,
Please submit on that issue, because this is your core case.
Lordship.
If this word consultation means it is mandatory, then you have a prima facie case, will continue with the interim order. If it is not mandatory, only merely consulting someone.
Lordship, take up on Tuesday, I will.
You have to address
Yes,
on this
yes,
issue. Have you
Lordship, on
understood?
that one, Lordship, I will cover it.
The petitioner relies upon the word consultation appearing at page 28, that the inspector schools, after consultation with the principal, headmaster, and local people, forward two names. That it would be mandatory for the inspector to recommend only the two names given by the principal after such consultation. In other words, we are to interpret the word consulting, whether it is shows a mandatory nature of the name forwarded by the principal, or it is merely directory in nature to aid the inspector for choosing the appropriate person for being the president and vice president of the school managing committee.
And
For the purpose, Mr. Borhuya seeks my adjournment to be listed on so.
And one more issue, my lord, whether the name recommended would confer any right to challenge whether the selection.
That's what the answer of this one will be. If it is mandatory, it will give him a right.
My lord.
90.
Obliged.
And Mr. Kaushik, you also come ready, whether it is mandatory or not.
I'll find out.
You bring your materials. Next item. GSA Eduki. I think বেলেগ তো দি দিয়া এটো লাষ্টত লম
Item 57 and 58.
Yes, Mr. Gogoi.
But I've got that.
Is there any such
No, man. Properly followed, man. Just I placed.
Have you gone through it? Did you notice any such candidate?
No, man.
Then we close this petition then. If nothing else is there. Our order to key this sound. Mr. Fukon, we feel very bad when somebody repeatedly says that we are not hearing. Yes, we have to hurry up matters. See the workload we have. And we have to give proper hearing to everybody. Some 60 or 70 odd matters are there. Out of them, several long-drawn matters. And we give hearing to everyone as long as what is being said is relevant for the purpose. But we cannot accept that we are not being heard just because somebody wants to repeat the same thing. And if you want to add something more, please add. We definitely will hear you. But prima facie, what we said, it appears to us. Because this is the third time. And we expect the university not to treat the court orders in this manner and not to find out a way out to circumvent. It's a responsible institute for the university. How do you feel? Is it not so? Suppose today you would have been on the other side, how would have you felt? Just what giving time to give a meaning of the word note. Word note is do the needful after looking at it, whatever is provided there. That is the only meaning of the word note. That doesn't mean, otherwise what will happen from next time onwards, we'll start sending it back to the authorities. We'll pass every order here itself. Finish it off.
Possibly it's misinterpretation on their part. There's
It
no
cannot
date.
be.
They
Otherwise,
thought it is not compliant.
read, and you cannot take, just extract out one word from a judgment. You have to read context of the judgment. And that was explained in the next judgment. We took a very lenient view on the second occasion. That first time you may have missed out. But second time, when the executive council, a responsible body, starts giving their own reasons, own interpretation of everything, and in the end says, go and tell the court that this is our. Apprise the court means go and tell the court that you are passing those judgments. These are what we find. Now we go and tell the court.
Possibly they should have
Just as an officer, honest officer of the court, please tell us, should the court accept that? And the remedy is always there. If the direction of the court is wrong, file a review. Immediately we'll reconsider everything. With the cost of repeating, we say courts have no ego. We are ready to correct our mistakes if a genuine mistake is pointed out. That so and so thing aspect was not taken note of. Yes, good ground for review. We'll review it. But how does the court feel when the executive committee says that these are reasoning? Go and tell the court what kind of judgments they are passing. Is it not a contempt? Is it not a contempt? So we wanted to issue a contempt notice. That's all. Other alternative we are given, if you want to introspect over the thing, we give you time. Both. Because it's a very high authority executive council, we are aware of it. But that doesn't mean being a high authority, we will treat the courts in this manner. Mind you, you are an officer of the court. Your own institution is being.
I'm also part of this.
Your own institution is being degraded by these things. And over and above, you are telling us, I'm not being heard. And hearing the way litigants want, we can do it. We don't mind hearing one matter for a whole day. Ultimately, end result, what will be? Out of the 70 matters, 69 will be left over. Okay.
40-50,000.
Tomorrow, this 69 and another 70 will be listed before the court. We'll hear again one matter for the whole day to the total satisfaction. Say whatever you feel like. We'll just lean back and with a blank face keep on looking at you. Say whatever you feel like. Go on and on.
I understand.
Third day it will be how many matters? 139 matters will be left over. Fourth day it will go on increasing like this. What will happen? Are we not required to speed up a little also? And how can we do it? Whatever relevant you were saying for deciding, we give you a complete hearing. Like Mr. Gogoi, Mr. Ganguly. Their matters have been heard for the last almost 7 days, I think. Even Mr. Nair was a amicus in that matter. It required some hearing. We are hearing you. Is it not so?
I understand.
Then, and when somebody says shouting from the near the door that I am not being heard, how do you feel the courts feel after the end of the day's work? After sitting here from 10 o'clock, continuously hearing, how will the court feel? He also. So if you have something actually to be taken note of, please submit. We'll hear you. But see the language of that order, court goal file too. You read it once again, how it.
What had happened here was somebody had placed a note before the EC with an observation that the committee's report should not be accepted. That was what was, my lord, accepted by the EC. And they have now, I had some doubt in that, they have filed an affidavit and they have said that we had given a note to the committee and that note, it was written like this. How can that be when my lord is requiring the EC to consider? There is a way to do things.
So you do one thing, you can take up with your authorities, confer with them, tell us. You can do that. We are giving you that opportunity. But if we allow it to remain as it is as on today, It's an out and out willful and deliberate violation of the court's order. Number one, lowering the majesty of the court. Number two. And these are two clear cases of contempt. Your registrar will be in trouble. That's why I say you may take 1 minute. The meaning of the expression you may take 1 minute, but several minutes will be consumed. This is a clear case where the registrar has to be, an order of contempt has to be passed. Result will be he will be imprisoned for some time. Those minutes will be more precious for him. And maybe it's a possibility that the registrar and the council has not understood anything also. Somebody is misleading somewhere. If that is so, you being the learned counsel, tell them.
Some legal opinion.
Can you ever conceive of a concept that the court take note of this particular thing and that to quote it? Whatever is to be done in court is quoted already and pass your order. This means that the court, instead of passing the same order itself, has only given the due respect to the authorities that you do it yourself after deciding the whole issue. Now, if the authority comes back and says, writes all kind of things for 1 page, then say, go and apprise the court. What is the meaning? Please understood in the totality of the situation, not just one word here and there, or not what your clients must have instructed you. You are not bound by that. Being an officer from the court, you can always overrule the instruction. Mr. Gogoi must be aware. They also keep doing at times. They reject what the officers are saying.
They take it on themselves.
It should be legal. Otherwise,
and if you feel that that recommendation, that order to pass a resolution taking note of the recommendation ought not to have been passed, file a review petition. We'll definitely hear you, everything in that. That's the way how the system has to work. System cannot work in a manner that a litigant will tell the court after the order is passed, that these are the things, go and apprise the court about it after the judgment is passed. And when he questioned it, be aggressive and say, I am not being hurt. What is there to be hurt? You read that offending page and find out yourself what is there to be heard in that case, other than issuing a contempt notice.
I understand.
Read it once again. I think with a cool mind, you sit down and please read it. I think if you were sitting here today, you also would have taken the same view. Please read it once.
I have gone through the
yes.
2 pages.
Have you understood what is it?
But normally there are 2 interpretations, one broad and one narrow.
Nothing like that. There is interpretation is only one. And those broad and narrow interpretations may be principles of interpretation when you interpret a statute. There is nothing called interpreting a court's order. Court's order are as it is. Have you come across any book interpreting a court's order? But there are so many books interpreting a statute. Why?
The court's order is loud and clear. To be
now, if the court order is ambiguous, next remedy, file a clarificatory application. That after reading the order, it appears to us that on one hand, court has asked us to go to Ganeshguri, on the other hand, they also asked to go to Panvajar. Which one to go? We are confused. Then we'll clarify it. Go to Panvajar or go to Ganeshguri.
Possibly they misinterpreted the word noted. They noted 8 recommendations.
What does the word note mean? Sound dictionary comes sound. Let us take a look. And word note is not to be read in isolation. It has to be read in the context of the entire order.
In the context of the 8 recommendations, 8 recommendations have been dealt with elaborately.
But what to do? This is a recommendation by a subcommittee constituted by the Executive Council themselves. It is your own one. And we are not decided anything. We just say, whatever is the recommendation, and pass an order on that. But if your stand is the recommendation is wrong,
against the statutory provision,
you should have done it in the writ petition. That the recommendation of our own subcommittee is wrong, so it should not be taken note of. We have passed the order that way.
That has been reflected in the last 2 pages. Lord, that is why
What? That the recommendation is wrong.
Yes, Lord, the statutory goes
Who
against
in our order it is reflected.
no, that committees.
That you cannot do anymore. This is what we are saying. You are precluded, and that entitlement is already, that stage is already over.
Right.
It ought to have been the stage in the first writ petition. Whatever you were provided in the impugn order ought to have been your stand in the first writ petition.
Lord, the university's interpretation little bit, Lord, easier. That noted they have thought that it is not to comply with.
No,
just
no,
to note.
no.
But if it is
So
noted,
therefore we clarified it in the second judgment.
noted means comply with, then they will have to comply with.
Definitely they have to. Or else you file review. You are still at liberty to file a review if you are. And once you file a review, we'll open up the entire issue. We'll definitely hear you. But not in this circumstance. Once we do it, mind you, that is the beginning of the end of the country. Once we start doing this thing. I don't say call it end, that's the beginning of the end, the day that happens.
Since I am also part of this institution.
Therefore, the example I gave you, there's a hierarchy under the Constitution. Once you break this hierarchy, tomorrow the grade 4 will going to go against your deputy commissioner or your registrar. Why? There is no hierarchy. The registrar says, go and get this file, the grade 4 will say, no, you take the other file, not this one. What will the registrar do? Suppose sitting in the office, registrar says, get me X file. Grade 4 comes and tell him, take this Y file and work on this. You are not required to have the X file. What will the registrar do? Tell me. What will he do? That will happen if the hierarchy of the under the Constitution is broken. Mr. Gogoi, is it right or wrong? If the registrar is allowed to behave this way in the court, we are also bound to allow the grade 4 to behave that way in the registrar. To file the op. That he is not interested to work, he just go to the shelf, pick up any file, work on this file. What will happen?
It will be a chaos.
Will the system not collapse? And that too, the act of the grade 4 will be legitimized by the same standard that is sought to be adopted by the Executive Council. It will be legitimized. Grade 4 will next come and say, if any action is taken, you Executive Council had done this to the court. So I grade 4 is also authorized to do this to you. Suppose he gives a reply to the show cause, what will you do? But a grade 4 can always tell the registrar, sir, see, you have asked for X file, but I am also little experienced in this department. I feel it should be the other file. So therefore, I have brought this one. Please see to it. If you have instructed the wrong file, that is something totally different. So your approach also, that will do it, if you do it. Anyway, what to do now?
Your Lordship
Let
has
them have
already
a,
stated
let them have a
that,
relook. Let them have a relook. If there is some genuine reason, fine, my lord. There is nothing like that. But
I will
this should
confer
not be
with
the
the
way.
university authority.
Sorry?
I will confer with the university authority.
That's the right thing. It's good for you, I am telling you. It's not nothing for us. Today we are here, tomorrow will not be there.
My lord, one case, she may
But
get,
the
she may
courts will
not get.
always be there.
She may get, she may not get, but it
That
should be
is
the
totally
proper manner.
something different. We are not at all on
There
that.
should not be any legal chaos.
My lord, that's it. My lord will have it
Mind
next week.
you, the difficulty will be overall adverse effect on the country as a whole. Once these approaches are constitutionally allowed, it will be the beginning of the breakdown.
Will be anarchy.
Anyway, lot of anarchy nowadays. Society knows only to oppose. Society doesn't know anything to take the country forward. Read the newspapers. Most of the news you will find not where the country is going forward, but pertains to oppose. Right? Opposition should be constructive.
Yellow journalism,
We don't use those terms, but thing was noticed. So, when a vehicle is moving, you take a ride in a vehicle from going to X to Y place. If you don't allow the vehicle to move forward, will you ever reach Y? If you allow the movement of the vehicle to be opposed at every stage, will you ever go and reach a destination? Will the country reach its destination? If at every stage. But again, contradistinction with corrective measure. You can always suggest corrective measure. Just see, this may not be all that correct. I think the other way it will be better.
There should be momentum in positive
Please
direction.
look into it. That's a very good approach. But will not allow you to go. Then what will happen? Anyway, word note. Let us see what it means. I think this is the appropriate. Used here is used as a verb. Notice or pay particular attention to something. Attention to something. And whatever that something requires you to do,
do it.
Do it.
Take notice of.
Take note of it, and whatever it requires you to do, do it. That is the only meaning it was used.
Pay particular attention to something.
Something.
And that something, my lord, is defined as that.
That recommendation is a something. And whatever that something requires you to do, do it.
I have done.
You cannot distract that something. Taking note does not mean the authority is asked to destroy that something. Taking note is to carry it forward.
That's something.
Of that something, whatever that something requires to do.
One recommendation has been given by that committee. That should be noted.
And whatever it provides, do it. And if you feel
if it goes against the statutory provision,
it cannot be done.
Then take
review.
action.
No, take review. Not you do it yourself.
Come back.
Otherwise, you are substituting yourself to the judgment of the court. That you cannot do. Somehow the law of contempt prohibits you from doing that.
Review would have been the better. option.
We are never saying that your reasons are bad. We are not at all on that. Maybe that's the best of the reason.
Manner.
But
manner it will be.
You cannot tell the court that this is in person to your order, we have taken note, these are the views, go and apprise the court. Can you do it? So, what to do?
Lord,
I do list on swings on the previous study.
Next week, 10 days.
2 weeks at least, my lord. I will confer with the university authorities and I may be given the liberty to file review.
We cannot give liberty. No. You file, we'll take note of it if it is there. If it is not there, but this order you'll have to withdraw. Before that, you will have to withdraw this order. Because there is a proposition of law, I think 1966 All England report or something. First, you purge the contempt. Then you take any other action you want to take. The contempt has to be removed first.
Then other measures and
if the contempt is purged, this petition becomes infructuous. After that, you are at liberty to do anything you feel like.
Understand.
But not with the contempt one. I think I'll give it a citation. I think 1966 All England report. I've forgotten the name. The Supreme Court is heavily relying on that. Before you take the next step forward, first purge the contempt and then go for the next step.
It's a little bit of that doctrine of eclipse. First, that would have to be removed.
And that has to be removed. So this is what we are trying to point out. And Mr. Foucault, when we express something, there is a reason. We don't react to something for no reason.
My lord.
We don't react to something when there is no reason. When we react, that there must be something, some reason. It's always better you try to understand the reason. Otherwise, your man will be in problem. That order would have been passed. Have you noticed one thing? The register would have been in problem. And there is enough law in favor of a contempt to pass a contempt order against him.
Understood. I'm really sorry, my lord.
Okay, no, it doesn't matter. It happens. These things I don't retain anything. But sometimes, on the circumstance, the reaction would also have to be a little severe if the circumstance demands it.
My lord.
John.
Obliged.
Yeah, আগৰ অৰ্ডাৰটো চাওঁ এটা যে আধা ডিক্টেট কৰি থোৱা আছে ইনডেক্স আইটেমটো গাঙ্গুলি
Deeply.
Thank you. So list on something. You take a date. Then Mr. Gogoi, Mr. Ganguly, we are not going into so many things. And nor we give any approval to the second proviso. Only thing that this is the issue raised, we have verified from the record that there is no such instance where a person who was entitled to a UR seat opted for a EWS seat in another college. Result thereof, his second preference choice of college, a seat there UR seat has to be converted to EWS. As the circumstance is not available, the possible claim of the petitioner is also be and close the petition. And this complicated legal issue, let it remain open for the next year. And for your case, why don't you simplify the rules?
That I have conveyed already.
Only
Yes.
one thing.
Some, my lord, brush up will be necessary of this. Like
Everything in the order of merit.
No.
Okay. Suppose in order of one EWS misses out a cutoff under UR in any of the institute where he is interested. He can straight away avail the EWS. of that same institute. End of it. Instead of going to that para 10 of that, what was that? Tripura. Or else the same problem will be there next year also. Mr. Ganguly is already aware of the law.
We'll recur again.
He will come back to you next time with the same argument.
I have discouraged it.
Sorry.
It's too late. There are other petitioners who wanted to go into.
But now it's too late. Even the other, that lady we have told them, she came out with the cause of that,
Law is very clear at this stage. There should not be-
that non-creamy layer certificate. Central government is not raising, although they are required to raise. Not MOTOP. One non-creamy layer
NCL, my lord.
is 8 lakhs. She makes a submission, she is right, saying that every 3 years it has to be reviewed. For the last 6 years, it is not reviewed. Had it been reviewed, she would have come in. She has a case, but what to do now?
In fact, my lord, Google has got the instruction, my lord. The 2017 is the last, my lord, updated.
So once it is last, there is no point. Maybe you can admit her petition and ask them to review it for the next year. But
this time it will be too difficult. One, my lord, in between, I like to make one unusual prayer. This matter was listed on Monday, last Monday, my lord. But before it's taken up, my lord, lordship had to rise, my lord. And the matter relates to, my lord, NCL, my lord, non-issuing of the non-familiar certificate.
Which petition?
There is one matter, my lord. May I please, can it be taken up tomorrow because of the procedure of time it relates to medical admission.
Tomorrow.
Just now, the director of medical admission informed that, my lord, there is an interim order occurred.
Yes. All medical admissions, whatever is brought, bring it by tomorrow, because otherwise Friday will be the last day.
Lordship.
Heard Mr. A. Ganguly, Land Counsel for the petition, also heard Mr. V. Gogoi, Land Counsel for the Health Department of the Government of Assam, and Mr. D. K. Vaidya, Land Counsel for the authorities under the National Medical Council. By referring to the second proviso to the, where is the roots? Mr. Gogoi, can I have your... By referring to a second proviso to Rule 8C of the Medical Colleges and Dental Colleges of Assam bracket regulation of admission into first year MBBS or BDS courses, Rules 2017. A submission is made by Mr. A. Ganguly, Land Counsel for the petitioner, that the procedure, that under the procedure prescribed therein, there is a requirement of law that if any candidate belonging to the UR category is entitled to a seat in the first year MBBS course, but the same candidate would also be entitled to a EWS quota seat in another medical college, and accordingly accepts the EWS quota seat in the other college. In such event, the EWS quota seat in the other college would be deemed to be a UR seat, and to maintain parity of reservation, the one UR seat in the college of second preference of the same candidate would now be converted to a EWS quota seat. Fine, in one line. According to the petitioner, in the results sheet, no, is it a result sheet or what is it called?
Compilation.
In the compilation of students entitled for admission to their first year MBBS seats, comma, the aforesaid requirement of law had not been duly followed And because of the same, the petitioner who is a EWS quota aspirant was deprived of a seat or deprived from being admitted to a seat under the EWS quota. Without going to the question of the applicability of the provisions of the second proviso to Rule 8C of the rules, we required the respondent authorities to verify from the list of eligible, from the compilation of eligible candidates as to whether the list shows any such candidate who is otherwise entitled to a seat under the UR category, but had opted for a EWS seat in another college, and that EWS seat in the other college was deemed to be a UR seat, resulting in one EWS seat being made, resulting in one UR seat being converted to EWS seat in the college of second preference of such candidate. Mr. B. Gogoi, learned counsel for the respondents in the medical education department, has made a statement that after verification of the entire list, no such candidate could be located who was entitled to a seat under the UR category in any of the colleges, but had opted for a seat under the EWS quota in another college, and which again under the law was deemed to be a UR seat, requiring the EWS seat to be requiring one UR seat to be converted to EWS seat in the college of the second preference of the seat candidate. As no such candidates could be located in the list of candidates found in the compilation, which again had also been verified by Mr. A. Ganguly, learned counsel for petitioner, we are of the view that no interference as sought for in this petition is required.
I cannot verify this because I do not understand. That line may not be.
Okay, he said, yeah. No further materials could be made available to the court that the submission of Mr. B. Gogoi, learned counsel for the medical education upon instruction, is contrary to what is available in the compilation of the list of candidates presented. In the absence of any such circumstance existing as made out in this writ petition, we are of the view that no further consideration is required. Writ petition closed. You're not using the dismissal. Close it.
Close.
Yeah, I think same thing will do. Are we required to? That was a detailed submission we would have gone into had we taken the other way view. Here, without any interpretation, we are just examining whatever circumstance point out is unavailable in record. So I think that will do. And let the question remain open for the next year. Next year you try it out, which way it goes.
And that rules whether tomorrow I will take it.
The quote it's not required also quoting the rule.
His lordship has mentioned the rule 8.3. Maybe
no second provider.
Second, yes. No, may not be my other.
It
has been mentioned.
Also. And if you want to put that.